You know I've been waiting for it all weekend. I've already seen a little bit of some previews of some of the nonsense that is to come. But let's just see what we get. I might have to take a break during part of this. Hopefully, I can get through all of it today. We'll see.
Of decorum and civility.
Oh,
Third party intervener in that third party intervener in that matter appearing as authorized representative for my
yeah,
client
he goes
exemption
into
to
stuff.
dispute this morning.
All right, good morning. Person in custody, however, he is wearing street clothes, a suit and tie. Do you anticipate calling any additional witnesses today? Do you,
For the record, I don't consent to being called that name. And what was the question?
do you anticipate calling any witnesses today?
Um, I don't believe today.
Well, we are here for the continuation of testimony. The only witness that I'm aware of that's on your list that you added is your mother, Dawn Woods. So I would expect that if she's going to testify, she would be here.
What did you think you were gonna do?
I will.
What did he think he was gonna do here today? He was gonna show up and just argue with the judge. Oh man, dude, you're just killing yourself. You're just signing your fucking.
We'll be going through the colloquy with you as to whether you intend to testify today or not.
Did you receive my ICS that I addressed to you?
Oh, I haven't looked. Let me look.
Actually, I just went to you and then went to the prosecution. Is the audio on?
It is. The audio's on. Like the inter-office communication.
22nd.
State receive anything through like the inter-office communication?
We have not. I just checked this morning to see if there's anything new. Nothing has been received at my office. And I should say the clerical that was assisting me went to the mailroom to double check. So not only has it not made its way to the DA's office, it hasn't even made its way over to the mailroom.
I can email the jail administrator to find out if there's anything in transit, if there's no objection from the parties, from the state. From you, sir?
No objection. Information.
Morning after those are 2 ICF forms.
Yep, one addressed to you directly and one addressed to the district attorney's office.
Starting off pretty smoothly. I know it's gonna go off the rails, but so far we're doing okay.
I'm sending that. I will send it with high importance and we'll see what response I get. Cover it verbally.
The topic is pertaining to exculpatory evidence. Some things were learned, and once they came to my attention, I felt the need to immediately address the court about this information.
All right, what information make enough of proof for me, sir?
The expert witness for the prosecution in regards to, I believe it was inspecting the vehicle, Officer Ryan Schultz. Question was asked of, did he know if there were any recalls on that vehicle? And I believe that a Brady claim should be visited because there were, in fact, recalls on that vehicle. In fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where Ford Company were sued because of this, and those vehicles, models from the year 2008 through 2010, were recalled. And that is very important information in regards to the vehicle in question being a Ford Escape 2010. This information is very easily obtained just by pulling it up, and you will see a class action lawsuit. Obviously, if it's a class action lawsuit, then it's pretty easy to
So what's your request, sir?
My request is to find out if Officer Schultz knew, to find out if the prosecution knew that there was a recall on those vehicles. And in light of the fact that these vehicles were recalled because of this malfunctioning throttle body for, I believe it's counts 1 through 73 to be dismissed.
All right, what's the response from the state defendant?
Thank you, Your Honor. As Trooper Schultz testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape. As Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old and has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body failures would have resulted in engine stall or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here. Further, Inspector Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator lights. None of them were lit. Further, if there was this, he would have observed material buildup on the commutator. There was no such buildup observed. There were no problems with the throttle, electronic throttle body. That was part of his report. Therefore, this is, although there may have been some cars who had this problem, the car that the defendant was driving on this day did not have that problem. That was testified during the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's.
In other words, everything he just brought up in court has already been proven.
Traffic and Safety Administration. There are
proven to be false. Proven to be
that the defendant was driving. Zero unreported.
There was no problem with the vehicle.
So it's a mood issue.
I don't believe it's a mood issue, and I actually have. The report should be in the mailroom as we speak. I had everything sent over priority mail. The actual information about the class action lawsuit, the actual information about the recalls for those models, like I said, 2008 through 2010. Now, in all fairness, Your Honor, that's why I was asking for a Brady claim on this. Seeing as how when vehicles are purchased from the manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens. And seeing this a class action lawsuit, no one would sue the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit if these vehicles were not malfunctioning. And I believe with that, like I said, the information is easily obtainable. I should have the information in the mailroom right now that you can readily view this information about the class action lawsuit, about the recall. It wasn't just the 2010 model in question, it was 2008 through 2010. The information about the malfunctioning pertains strictly to the throttle body.
Let me address your claim, sir. So, not trying to cut you off, I don't need the specifics about a class action, because as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to cross-examine the inspector regarding his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls, and more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email, it's one page with what you said. I have to turn my head, I gotta figure out how to flip it. So give me a second.
Okay. Just for the record, Your Honor.
Hold on, let me finish my record, okay? So I'm gonna turn, because it's the only way I can read it. It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital. I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother, and from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding the recalls and what to do, and presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone else who operated that did anything with it or not. The bottom line is there is absolutely no Brady violation by the state. This is not the type of information they would have been required to turn over. And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that would have impacted the mechanical function during the incident in question. I'll accept the state's offer of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to dismiss the case, and I'll deny the request to recall this witness.
Your Honor.
Hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him and was asking questions directly related to information contained in that report.
All right, go ahead, Mr. Brooks.
When you spoke to the owner of the vehicle, that's who gave me the information. My mother gave me the information of this. I had no knowledge until she told me. And that's how I came into the information. And she was the one that said, I'm gonna send you all the information that you need so you can present it to the court. So
I understand that, sir, but your request is not timely. So you have had this information for quite some time, either through counsel.
I did not have it for quite some time.
Let me make my record, either through counsel.
It was just told to me.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. And I understand that may seem fair to you, but even when I consider the information that you're providing to me, it's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done. And you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not readily available for me to expect at the time. I don't have access to the internet. So how would I be able to?
Mr. Brooks, you're telling me your mother had that information.
No,
so,
I'm
and
telling
I'm
you,
trust...
she just told me this information. I have the phone calls to prove it.
I understand that. I'm denying the request, sir.
And I would like a.
So that's my decision.
I object to that, Your Honor.
I understand. I've made my decision. I expect that you respect the decision, at least, as we're not going to debate it further.
Yes.
I now have the ICF
It
The
needs to
one for
be
the state
addressed,
was
Your
provided
Honor.
for the state.
It
Madam
needs to
Clerk,
be
I just gave
addressed.
that to you. All right, so,
I
Mr. Brooks, in
respectfully
light of that,
object. I respectfully object, Your Honor, and request a legal reconsideration of your ruling, Your Honor.
it's denied. The request for reconsideration is denied. There's no legal basis for me to do
I
that at this point.
respectfully reject that ruling and take exception to that ruling, Your Honor.
All right, Mr. Brooks, we need to keep going.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue?
Your request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
I wouldn't be the one you would make that request to, sir, so I
For the
can't
record, may I
answer that
move
yes
to
or
stay
no.
these proceedings until the instant matter is adjudicated by a court of competent jurisdiction?
That request is denied.
Based on what law or fact, Your Honor?
The request is denied.
Based on what law or fact, Your Honor?
Any other requests, sir? I'd like to move on.
Based on what law?
There's no
Or
legal
fact.
basis that you've stated for me to do that, sir.
It has been, Your Honor.
The request is denied. The request is not a proper motion. There's no legal support for the motion. There's no factual support for the motion, so it's denied.
For the record, it appears that this court is acting in contempt of the law, Your Honor. Can you show me how or where this court is following the law of respecting this matter?
That's a very vague statement, sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact, so this court cannot address that last statement of yours.
Your Honor, with all due respect, I would like a motion for finding the fact.
Denied.
Under what law and fact?
I
Your
made
Honor?
an oral ruling, sir. There's no requirement I do so in writing.
So you're denying a legal, you're denying a motion for finding a fact.
I am.
So how do I know what you're doing is legal, Your Honor?
All right, Mr. Brooks, we're going to move forward. At this time, I want to,
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr. Brooks, we're moving forward. So your
Doesn't
request
seem
is
like you're-
denied.
it doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
It
advisements,
doesn't
and
seem
I'd
like
ask that you
I
stop
don't
interrupting
need your
me.
advice.
No, I have to give you advisements, sir, regarding
I
your
need
right
you
to
to
testify.
I need you to do your job without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right to testify.
You don't
Do
need
you
to
have
go
a
through-
witness to call,
You don't need to
sir?
go do anything with me on record. You
Actually,
need
I
to,
do so,
actually,
sir.
you
That is
don't.
required by law.
Actually, you don't. You need to do your job as a public servant.
Mr. Brooks,
and honor the oath that you
I
took,
need to
Your
go
Honor.
through these advisements, and if you're going to keep interrupting me, you will forfeit your right to be present, and you
So
will
you're
be
holding me in
removed to
contempt
the next courtroom so that I can properly go through these advisements
And
without
I
being
still,
interrupted.
And I still don't have to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court under Illinois versus Allen, under State versus Vaughn. It's also referenced in State versus Anthony. So I am going to keep going, sir, despite your protestations.
Your Honor, with all
I need
due
you
respect, in
to
Illinois
not
versus
interrupt
Allen,
me.
in
This is
Illinois
another
versus-
interruption.
In Illinois versus Allen.
Mr. Brooks,
do
I'm
they
not
say-
going to have a debate with you on
I'm
the
not
meaning
trying
of
to have a
Illinois
debate.
versus
I'm not
Allen.
trying
You
to
are,
have a debate.
you are
I'm really
advised
trying
that
to
it
understand
continued.
Illinois versus Allen.
Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that I'm
I've
forfeiting
said that
my
multiple
right.
times.
You
I've
saying-
given you multiple
You're
opportunities to
holding
stop
me in
interrupting
contempt.
me.
You're holding me in contempt.
Mr. Brooks,
By
I'm not holding
removing
you
me
in
from the
contempt for
courtroom.
the second time here, and I've
Your
also
Honor,
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with
Mr.
all
Brooks, I
respect-
need you to stop talking.
With all respect, in Illinois versus Allen.
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this court
trying to
that
understand,
he
Your
wants to disrupt these proceedings, even
That's
in
not true.
mild manner, tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
standards
because
of
it
form and
doesn't.
civility, and one of the
Illinois doesn't.
bedrocks is that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to the next courtroom so that I can go through
It does
proper
not state-
advisements with him without being
It
interrupted.
does not
We'll clear the
state
courtroom
that
and
you
we'll
could be
resume
present from
once he
cameras.
is over there.
It
Again, I'll make
doesn't
the
state that
appropriate
you could be
findings when
present
he is
from
there.
cameras, or that you could be,
Yes, we're off the record
or that you
until,
could be.
he's in the
Okay,
other
so
courtroom. I'll
you're
be
making a
stepping off.
tacit agreement for something that I.
All right, I apologize. I had to step away for a few minutes. It looks like I already missed something.
Options available to this court under to move forward.
Your Honor.
I understand.
I'll
I've made
check
my
to that.
decision. I expect of your offer of proof. This particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems.
Yeah,
Because,
that's not
again, there was a full, there be impact, the throttle
Full
body.
report of the vehicle.
I am aware what you said. I have to turn my head. I gotta figure out how to flip it. So give me a second.
Okay. Just for the record, Your Honor.
Hold on, let me finish my record, okay? So I'm gonna turn, because it's only I can read. It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital. I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness.
Yes.
This information was apparently
100%.
well known.
It
I'd also
was
note the
well
vehicle was registered to
available
your
at
mother.
the
And from my
time.
understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding the recalls and what to do. And presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone else who operated that did anything with it or not. The bottom line is there is absolutely no Brady violation by the state. This is not the type of information they would have been required to turn over. And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and
Yes.
found that as to this particular vehicle,
Vehicle?
there were no issues with that
No
would have
issues.
impacted the mechanical function during the incident in question. I'll accept the state's offer of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to dismiss the case, and I'll deny the request to recall this witness.
Yep.
Your
Hold
Your
on,
Honor.
hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him and was questioning, asking questions directly related to information contained in that report.
All right, go ahead. So,
I
Mr. Brooks, in
respectfully
light of
object.
that,
I respectfully object, Your Honor, and request a legal reconsideration of your ruling, Your Honor.
it's denied. The request for reconsideration is denied. There's no legal basis for me to do
I
that at this point.
respectfully reject that ruling and take exception to that ruling, Your Honor.
Don't
All right,
really
Mr.
matter.
Brooks, we need to keep
You do all you
going.
want.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
No, you may not.
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this
No.
issue?
Your request
Nope.
is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
We
I
can
wouldn't
move
be the
forward.
one you would make that request to, sir. So I can't
For the record, may I
answer that
move
yes
to
or no.
stay these proceedings until the instant matter is adjudicated by a court of competent jurisdiction?
The request is denied.
Based on what law or fact, Your Honor?
You almost
is
started
denied.
off these.
Based on what law or fact, Your Honor?
Any
Minus
other
the fact
requests,
that
sir, I'd
you-
like to move on.
Based on what law?
There's no
or
legal
fact?
basis that you've stated for me to do that, sir.
It has been, Your Honor.
The request is denied. The request is not a proper motion. There's no legal support for the motion. There's no factual support for the motion, so it's denied.
For the record, it appears that this court is acting in contempt of the law, Your Honor. Can you show me how or where this court is following the law of respecting this matter?
Yeah, that's the
That's a
wrong
very vague
question, sir.
statement, sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact, so this court cannot address that last statement of yours.
Your Honor, with all due respect, I would like a motion for finding the fact.
Denied.
Under what law, fact?
I made an oral
Under
ruling,
the
sir.
fact
There's no
that I am
requirement.
presiding over this court and you're presenting
So
information
you're
that is
denying a
irrelevant.
legal, you're denying a motion for finding the fact.
I am.
So how do I know what you're doing is legal, Your Honor?
All right, Mr. Brooks, we're going to move forward. At this time, I want to,
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr. Brooks, we're moving forward. So your
Doesn't
request
seem
is
like you're-
denied.
it doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
It
advisements,
doesn't
and
seem
I'd
like
ask that
you're.
you
I don't
stop
need. I
interrupting
don't need
me.
your advice.
No, I have to
need
give you advisements, sir, regarding
I
your
need
right
you
to testify.
I need to do your job without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I
Already?
need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right
You don't-
to testify.
You don't
Do
need
you
to
have
go
a
through-
witness
you
to
don't
call,
need to go
sir?
through anything with me on record. You need
Actually,
to-
I do so,
Actually,
sir.
you
That is
don't.
required by law.
Actually, you don't. You need to do your job as a public servant.
Mr. Brooks,
and honor the oath that you
I
took.
need to
Your
go
Honor.
through these advisements, and if you're going to keep interrupting me, you will forfeit your right to be present, and you
So
will
you're
be
holding me in
removed to
contempt
the
again.
next courtroom so that I can properly go through these advisements
And
without
I
being
still-
interrupted.
And I still don't have to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court under Illinois versus Allen, under State versus Vaughn. It's also referenced in State versus Anthony.
Gone over.
So I am going to keep going, sir, despite your protestations.
Asked and answered.
With
I
all
need
due
you to
respect,
Ground,
not
ground,
interrupt me. This is
ground.
another
in
interruption.
Illinois versus Allen.
Mr. Brooks,
do
I'm
they
not
say-
going to have a debate with you on
I'm
a
not
meeting
trying to
of
have a
Illinois
debate.
versus
I'm not
Allen.
trying
You
to have a debate.
you
I'm
are
merely
advised
trying
that
to
if
understand
continued
Illinois versus Allen.
Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that I'm
I've said
forfeiting
that
my
multiple
right.
times.
You
I've
saying-
given you multiple
You're
opportunities to
holding
stop
me in
interrupting
contempt.
me.
You're holding me in contempt.
That's not
Mr.
contempt.
Brooks,
That's
I'm
By
not
not
holding
order.
you in
from the
contempt for
courtroom.
the second time here, and I've
Your
also
Honor,
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with all
Mr. Brooks, I
respect-
need you to stop talking.
With all respect, in Illinois
You're not-
versus Allen.
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this court
trying to
that
understand,
he
Your
wants to disrupt these proceedings, even
That's
in
not
a
true.
mild manner tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
the standards
because
of
it doesn't.
civility, and one of the
Illinois doesn't.
bedrocks is that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to the next courtroom so that I can go through
It does
proper
not state-
advisements with him without being
It
interrupted.
does not
We'll clear the
state
courtroom
that
and
you
we'll
can be
resume
present from
once he
cameras.
is over there.
It
Again,
doesn't
I'll
doesn't
give the
state that you
appropriate
can be
findings when
present
he is
from
there.
cameras, or that you could be,
Yes, we're off the record.
or that you
until
could be.
he's in the
Okay,
other
so
courtroom. I'll
you're
be
making a
stepping off.
tacit agreement for something that I.
All right, let's find the next tidbit of juicy goodness. I've heard some pretty interesting things.
All of those things I either deny. Following, I indicated I wouldn't explain that further, that I made a decision on his motion to dismiss and his request to recall a witness. He then asked if for written findings. I denied that. He then asked for what law I was following. I indicated I wouldn't explain that further, that I already made an oral ruling. He asked for a stay. He asked for dismissal. All of those things I either denied or said I wouldn't answer, specifically as it relates to the request for an interlocutory appeal, since I would not be the judge or court to which a request would be made. That is something that would be made to the Court of Appeals. And although I would have authority to grant a stay pending appeal, there is no appeal that's pending. I gave Mr. Brooks multiple opportunities to stop talking. I asked him repeatedly to stop interrupting me. I advised him that if he continued, he would forfeit his right to be present in this courtroom
Yeah,
and
you
would
did.
be taken to the neighboring
Ah,
courtroom.
he's hiding his
believe I
face with
gave
the
that
Bible.
warning at least twice. And of course, this comes on the record before this court over the first 15 days of trial, where Mr. Brooks has, by his conduct, forfeited his right to be present on a number of
You're dealing with a child.
occasions due to his
This is a
conduct. I
child.
do appreciate that this morning he didn't yell at me, he didn't raise his voice, he didn't speak in an angry tone. But given the history in this case leading up to today, and knowing what this court needs to get through in terms of whether he has any witnesses or whether he intends to testify himself, there's a very
I
important
hope he testifies.
colloquy I need
I'm
to have and an
hoping, I'm
advisement of
praying
his
that he
rights that I
testifies.
need to go through, and I simply am not able to do that with him constantly interrupting me and then not respecting the oral rulings that are made. Of course, at any point in time, Mr. Brooks can ask to be brought back over to this courtroom under Illinois versus Allen. Of course, he needs to pledge that he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I, of
Which
course,
he hasn't done
repeatedly,
since
even
day
without
one.
him making
Not
such a
since
pledge,
day
brought him
one.
back into the courtroom where I felt a sufficient time has passed.
And every day where
He
you
at
think
many
he
times
might
has
have
been
learned
able
his
to
lesson,
conform his conduct.
every day.
I would note during the
He comes
vast
back
majority
fresh.
of the
Same bullshit.
testimony that was provided during the state's case, he was in the courtroom, if not during the entire time. He was able to cross-examine witnesses. We had a couple of issues during the testimony of witnesses he called, and of course, last Friday was, in my opinion, probably one of the most challenging days, I should say, to date. It's my hope that we can continue with Mr. Brooks in this courtroom. At some point today, I'll certainly invite him back over when I get through these advisements. Mr. Brooks, you have been muted. I will make that, put that on the record as well. I will unmute though and ask Mr. Brooks, because you did not answer the question previously. Other than you potentially testifying on your behalf, do you have any other witnesses present at the courtroom, at the courthouse to call today? I need an answer to that question, sir.
So we addressed the subject matter jurisdiction that we haven't addressed when I was just over here, or since I've been over here? Are we addressing
Did he
subject
really?
matter jurisdiction?
I'm going to mute him just for a
Oh,
second.
boy.
No, I'm not going to address subject matter jurisdiction. This is a common ploy by Mr. Brooks. When I attempt to go through certain things with him, ask him questions, he tries to divert our attention away to subject matter jurisdiction. I have issued a written decision on that. He has not filed any type of interlocutory appeal regarding that. This court's position is there is subject matter jurisdiction, and I'll deny verbally and orally at this point his request to dismiss the case based on a lack of subject matter jurisdiction. Mr. Brooks, I will be asking you a couple of questions. I do need a response. I am unmuting you. Do you have any other witnesses other than yourself available at the courthouse to call this morning, meaning now?
Now.
This is the jurisdictional challenge right here. So are you gonna address subject matter jurisdiction?
We're not doing that.
For the record or not?
So I've asked Mr. Brooks twice now whether he has any witnesses to call other than himself. He has declined to answer that question. Sir, if you fail to answer that question, I will interpret your failure to answer that as a no, and you will lose the opportunity, you will forfeit the opportunity to call any other witnesses on your behalf other than yourself. So I will ask you one last time, sir, do you have any other witnesses at the courthouse available to testify right now? I'm not getting a response at all.
Am I unmuted?
You've been unmuted, sir.
You just said I was muted, so I'm not sure. I don't know when you muted me and when I'm not muted.
Well, me muting you doesn't affect you being able to hear the court, because
Yes, it does.
that
Yes,
only
it does.
mutes your audio coming into this courtroom. I confirmed already
Here it is.
I'm
that
audio muting to begin with.
that is simply a misstatement. I confirmed.
He's already said. He said on Friday. He said, if you're not gonna listen to me, if you're gonna mute me, why should I have to listen to you, dude? You're just you're killing yourself, man. You are.
Confirmed with the bailiffs that the audio and visual were
Why
working.
Why is my audio muted to begin with?
Because you interrupt the court repeatedly. So I'm going to ask you yet another way, even though for 3 times now he has failed to answer this court. You indicated last week that you would like to call your mom as a witness, Dawn Woods. You were provided with notice that the state would not be assisting with that in any way. You indicated when that was said that if you wanted your mom to testify, she would obey you and she would be here. So I trust that you've made arrangements for her to be here. Are you going to call Dawn Woods as a witness this morning, and specifically now? I will ask him a second time. Sir, do you have Dawn Woods available to call as a witness this morning? He's been unmuted for a while now. We can obviously hear him. I will ask Mr. Brooks a third time for the record. He's finally putting on the headphones. Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her?
Hold on.
For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear it. I don't need to be muted
Mr. Brooks's statements that the audio doesn't work when I mute him is simply false.
I didn't say nothing about the audio not working, so you need to stop lying on the record.
I'm not lying on the record, sir.
You are lying on the record.
All right, he is getting, I'm going to mute him once again because now he's raising his voice. Now he's angry. He's thrown the headphones. He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses, other than perhaps himself. I then specifically asked him about Dawn Woods, because that is the person he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that. Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses, again, other than perhaps himself. I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in this case. I would direct Mr. Brooks to the case of State versus Anthony, although that squarely dealt with a person's right to call to be themselves a witness in their own case. They talk at length in that case about how rights, even constitutional rights, can be forfeited by conduct. Of course, the right to be present can be forfeited by conduct. That was established in Illinois versus Allen. And then the right to present evidence on your behalf can also be forfeited based upon conduct.
Misconduct.
Not
conduct.
A criminal
Misconduct.
defendant does have a right to present a defense. Doing so must be guided by the rules of evidence, the rules of procedure, and also with respect for the dignity, order, and decorum that is needed in the courtroom. Mr. Brooks has demonstrated this morning that he is not willing to answer simple questions about calling witnesses. He reverts back to raising the issue of subject matter jurisdiction, which, as this court has previously found, I believe is simply a distraction tactic, a delay tactic, and a disruption tactic. When considering that the court must be concerned not only with the defendant's right to present a defense, this court must balance that with preservation of dignity, order, and decorum, and the numerous procedural and evidentiary rules that control the presentation of evidence. Because in my findings today, Mr. Brooks has been unwilling to answer simple questions regarding the calling of witnesses. Again, I'll find that he has forfeited his right to present further witnesses. I would like to go through a number of advisements with Mr. Brooks regarding his right to testify. I will unmute him for that.
See, the thing is, he's got audio in that courtroom, and he pretends that he can't hear her unless he puts on the headphones, and he won't put on the headphones unless she unmutes him, and then the bailiff lets him know that he's unmuted because he likes to play stupid fucking games. You play stupid fucking games, you win stupid prizes. You're dealing with a child, and so she's treating him like a child, and I hope that they slap him with the full court costs of every day that every officer of the court has been there for his trial, because he has absolutely delayed everything. I like how he said, I didn't have it, this is taking longer, it's not my fault. Actually, it takes about 9 seconds longer to get one question answered when you have to object to literally every question that gets asked on baseless founds. And then you have to ask for grounds, not only, which you don't even get to ask for grounds for the judge's ruling, really, but for asking for grounds every time, even though you're just not going to get anywhere. You're obviously delaying. That's all you're doing. You're just biding your time until you get to general population and you get fucked like the little bitch you are. That's probably going to get me strict by fucking YouTube, but oh well.
I asked Mr. Brooks to put on his headphones if he is unable to hear me, and just to be 100% safe and secure on the record, I'd ask the bailiffs who are over there to advise him. I'm going to directly be speaking with him, and if he's unable to hear me, to put on the headphones at this point.
Handcuff his hands down
He's
to the
unmuted.
table. Like handcuff his hands down to the table, put the headphones on him so he can't take them off.
I've also been advised by not just the bailiffs who are over there, who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear.
Yeah, he can hear just fine.
Mr. Brooks, I would like to go through with you your right to testify and your right not to testify. We are at the stage in the proceedings where it is important that this court conduct a colloquy with you. I will advise you that if you refuse to answer my questions, refuse to acknowledge me, you can forfeit your right to testify on your own behalf. Again, that's State versus Anthony, 2015, Wisconsin, 20. Mr. Brooks, you need to be aware, and our has a book in front of him, although I haven't. And you, did you hear me advise you of that?
See, he's even putting it up. He knows.
No response by
You know
Mr.
he can
Brooks.
hear him. Well, there's
Sir,
a
you
response.
also you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that? Once again, no response by Mr. Brooks. The decision to testify is for you and you alone to make. Did you hear me say that? It's my understanding that Mr. Brooks has the equivalent of a 12th grade education, that he attended school either up to or through 12th grade, and either has a GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have
He didn't like
a
that.
high school education.
I'm talking
He is
about my
currently in
education.
custody, of course, at the Waukesha County Jail. I'm not aware of any medication that he has been taking. Sir, have you taken any medication within the last 24 hours, or any drugs or any alcohol?
That's a smart line of questioning.
I'm not receiving a response to that.
Of course he's not
I'm
gonna
aware that
answer.
he's able to read and write English. I would refer back to the record made during my
She is
colloquy with him
poking-
regarding the waiver of
she's
counsel,
poking him for
his
a
ability
response.
to be aware of rights, his ability to, I made a finding at that point of his understanding.
This is smart.
And based upon his
Oh,
conduct throughout this
question
trial,
his
including
understanding.
the waiver of right to attorney hearing, I'll make a finding that he has the ability to understand, he can read, write, and understand the English language. You've been unmuted the entire time, sir.
Is he talking about subject matter jurisdiction and how you going to verify it on record?
So he did not answer my question if the record's not clear about whether he's had any drugs, alcohol, or medication within the last 24 hours. I'll ask him, sir, has anyone made any threats against you to influence your decision on whether to testify on your behalf in this trial? Although he turned and said, what did you say? Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning in the other courtroom. He did not respond to that. Has anyone made any promises to you to influence your decision?
I don't hear everything you saying. So if you can hear me, I don't hear everything you're saying, and you know I don't hear everything you're saying. So cut the crap.
Mr. Brooks has interrupted with very disrespectful words at this moment. I believe that he is feigning his inability to hear and that he's done so throughout this case. There's absolutely no indication. He puts the headphones on when he wants. He takes them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them while in the other courtroom. But again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear, his statements that when I mute his audio, that it mutes his audio, are simply false.
So if
Mr.
I'm
Brooks,
still
have you
unmuted-
made?
Am I still unmuted?
You are, sir. And I'll make a record that per the lieutenant over in the other courtroom, the volume is 2 to 3 times louder than it is in this courtroom.
You need to stop making false records saying that I said I can't hear you at all. I said I have trouble hearing you when I'm over here. That's what I said. So I would appreciate if you would make the record clear and correct.
Clearly, he heard me say that for him to make that distinguishing
Yeah,
statement.
I'm sitting right
So,
here. Don't you see me looking all up to the microphone so you can hear me?
I don't have an
Or can
issue
hear
hearing
me
you
when
at all,
I'm
sir.
right here? Can you hear me when I'm right here?
I can. Once again, per the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom. Mr. Brooks, have you made a decision?
What about this courtroom?
Have you made a decision to testify in this case?
No. Have you made a decision to tell
I
me
will
what's
ask you
going on
again,
in subject
sir.
matter jurisdiction?
Have you made a decision to testify
Have you made a
in this
decision to
case?
address subject matter jurisdiction? Have you made a decision
Nope.
to be impartial?
You've been told
To answer
five.
what
How
you
many
asked
times
me?
that? No, it will not be.
Answer
She's
you
already
got
written.
questions.
I'm going to mute him for the moment just because, once again, he's attempting to divert away from what this court needs to do by going through the proper colloquy with him regarding his right to testify. He is asking me about subject matter jurisdiction. He's making statements about this court that are disparaging and about my oath. Again, a clear attempt, in my opinion, to simply stall these proceedings and to disrupt them I will unmute him and I will ask him for a third time with the understanding that if he fails
like fourth or
to answer
fifth
the
time.
question in the affirmative, I will interpret his failure to respond as a no and that he is not going to testify. So once again, I am unmuting him. Sir, have you made a decision on whether to testify in this case? There's no response by Mr. Brooks. I will ask it yet another way, sir. Do you want to testify on your behalf in this case?
Am I unmuted?
Yes, you have been. Sir, do you want to,
How long have I been unmuted? You
sir, do you want to testify in this
just said you
case?
was muting me when I had the headphones on just a minute ago. You just said you was muting me. So when have I become unmuted? Or did you even
I told
mute
you,
me the
like I
first
said. If,
Mr.
if,
Brooks,
if he gets
I'm asking
muted,
you one last
he's gonna
time.
pretend he
Do you
can't
want
hear
to-
her.
Because
He's
I
not
heard
going
that
to
you
listen.
asked, so how you gonna ask me something and then just answer for me?
Mr. Brooks, do you want to
You can't answer
testify?
for me.
All right, I'm
You
going
can't
to
answer for
answer.
me.
I'm going to
You
mute
can't
him
answer
again.
for me.
Again, it is very clear to this court that he uses the statement
Every
that
opportunity.
he can't hear
See?
as a means
See?
to delay. It's a distraction. It's very evident that he hears this court and that he's choosing to willfully not answer this court. This court, as I indicated earlier, is
So
tasked
painful
with
to
the
watch.
duty to ensure that there is efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer simple questions, including the rules of evidence. Forfeited is not ideal, but last time.
Yeah, I can hear him. I got the headphones on.
All right, then let's.
Obviously, you can see that.
Once again, Mr. Brooks is being disrespectful. He is
That's not being
blurting out
disrespectful. I'm
information.
saying
He
that.
reversed.
Understand.
Stop talking and I'll ask it again.
I didn't hear you saying.
Right not to testify of the Constitution forfeited is not ideal. At balance, this court will find that he has forfeited his right to testify. I've now made a much more full record of what is at stake, and I will give Mr. Brooks an opportunity again to go through the colloquy with the court regarding his right to testify. I am unmuting him and will attempt to go through this procedure once again. If he fails to answer these questions, then he is forfeiting his right to testify by his own conduct. I would acknowledge that such a procedure is certainly not ideal or making own that has forced the court to move through the questions again. So Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Are you aware that you have a constitutional right to testify? Mr. Brooks, are you aware that you have the constitutional right to testify?
Are you aware that you're practicing law from the bench?
Mr. Brooks, do you understand and are aware that you have a constitutional right not to testify?
I don't understand. No, I don't understand.
Are you aware that you have a constitutional right not to testify?
I don't understand, and I'm not aware. So why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right to testify and that if you choose to
I don't
testify,
understand.
that you would be subject to cross-examination by the state. Did you hear me say that?
I didn't hear you say anything. I don't understand what you're asking.
Yeah, because
He
you
is
won't
willfully
shut the
choosing not
fuck
to
up.
answer that. Sir,
Shut up.
you are also advised that you have a constitutional right not to testify.
Your Honor, with all respect, you've been trying
Did
to
you hear me say
answer
that?
questions for me. I didn't hear you ask me anything. And I
Sir?
don't understand.
Stop talking and I'll ask it again. Sir,
Can you ask me to stop talking?
I'm asking you to stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I will attempt to do this one last time.
Yeah, I can hear him. I got the headphones on.
All right, then let's.
Obviously, you can see that.
Once again, Mr. Brooks is being disrespectful. He is
It's not being
blurting out
disrespectful. I'm
information.
saying
He
the
reverts
fact.
back to subject matter jurisdiction.
saying
He
the
accuses
fact.
this court
No, I
attempts
said
to
practicing
deflect
law from the
away.
bench. I
I'm
said
going to mute him
practicing
once
law.
again, confirming on the record that he has been advised to testify. Again, that I needed him done. It is, again, from my proceedings, then he makes rules of evidence regarding looking at the to get on the witness stand, that he will abide by the repeatedly engage the court on the issue. This is a case, although not as for the defendant, was isn't a requirement to forfeit. You just as a been removed. Absolutely no individual regard to the Anthony autonomy. There's no right to prove evidence in Anthony to accommodate an evidentiary rule trial. Mr. Brooks, I've told him repeatedly his First Amendment free speech rights are not unfettered and that they are limited. That this court must go through are the interests, again, as I've.
So you're not going to protect my constitutional rights?
Are you willing to make that pledge, sir? I'm going to unmute you. If you can pledge to this court that you will honor that ruling and that you won't challenge that directly in the presence of the jury, I will bring you back over for that. Are you willing to make that pledge, sir?
Make what pledge? I'm not making no pledges.
Sir,
You're trying to, you asked me a question I can't answer.
Yeah, no, go ahead, answer.
You're trying to coerce me into violating my right to remain silent. How can you coerce me into my right to remain silent? So you're not going to protect my constitutional rights? Because I didn't answer nothing that you was trying to answer me before when I had the headphones on, and you can't make a decision for me. You can't do that.
Actually, she
You're
can.
violating my constitutional rights.
If you're not
Sir, if
participating,
you'd like to testify, then you need to simply go through the colloquy with this court, which I've given you 3 opportunities to do, and you have decided not to.
more than
No, you can't tell me what I decided to do because I didn't decide to do or not do anything.
yes.
You
By
willing
law,
to-
Your Honor, by law, you cannot coerce me.
I'm not coercing you, sir.
You made your own-
decision for me based on something that I did not say myself.
Last Friday, I specifically directed your attention to State versus Anthony. I discussed very briefly at the end of the day on Friday the case law that is relevant on this topic, including State versus Anthony, Rock versus Arkansas, and Chambers versus Mississippi, to specifically put you on notice.
Did you recall what was going on Friday?
Mr. Brooks, I'm going to mute him. Again, I'm not going to have a debate. I've made a finding. I've given him yet another opportunity. If he's willing to go through the colloquy with the court, he wants to challenge me instead and saying he doesn't consent.
He's not
His
gonna
lack of consent
anymore.
to this entire procedure is noted for the record. Based on his inability to pledge to this court that he will honor that ruling, sometime Wednesday morning or early afternoon. Ladies and gentlemen of the jury, at the moment,
I
Mr. Brooks
love
is
it when
appearing
he
from
shakes.
another courtroom. This must not be held against him in any way and must not influence your verdict in any manner. At this time, I will advise the jury that the defense case is rested, and I'll ask the state whether there's any rebuttal evidence to present.
No rebuttal, Your Honor.
All right, then with that, I will declare the evidentiary phase of this trial concluded. I'm going to excuse the jury for the remainder of the day so that the parties and I go through all of the jury instructions, and I anticipate bringing you in tomorrow morning. Instructions may very well take most of the day. My hope is to then have the closing arguments and then have the case be turned over to the jurors. If not by tomorrow evening, sometime Wednesday morning or early afternoon. With that, all rise for the jury.
Wait,
And
oh,
please turn
no,
your
now he
noses
wants to
the
testify.
back of the bathroom during deliberation.
Fuck you, Darrell.
Again, I will have Teresa print off what at least we do have back over. We are in recess.
Oh no, I cannot wait to see what happens after this.
I also have information from Zach Tremaine, our from the other courtroom as they were before. The record should reflect that Mr. Brooks continues to appear
We know it's not
from the
getting
other
any better
courtroom.
here, right?
I would like to make a record regarding the audio and visual from the other courtroom. I've asked that one of the bailiffs who was present during the last session, present in that courtroom, come to this courtroom. I'm going to put him under oath and have him testify about the audio. I also have information from Zach Tremaine, our IT specialist. He too will take the witness stand. And I just want to make a full record. He did a decibel reading regarding the audio as well. All right, we have Deputy Kibler. If you could take the witness stand, please. Sir, could you please raise your right hand? Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
It is.
Thank you. Please have a seat.
I swear this has to be unprecedented.
Please state your first and last names for the record.
First name is Nicholas, last name is Kibler, first name Nicholas, last name Kibler.
Thank you. And you are a Waukesha County Sheriff's Deputy?
I am.
And have you been assigned to work this case?
I have.
And were you present in courtroom 20 this morning with Mr. Brooks when he was removed from this courtroom to that courtroom?
I was.
And Did you make any personal observations regarding the audio and visual setup that we have over there?
Both the audio and visual were working properly. The audio was a lot louder than it has been in the past while we were in that room.
Did you have any difficulty hearing the court?
I did not.
And then, of course, you could see through the cameras from this courtroom into the neighboring courtroom.
I could.
All right, that's the only record I wanted to make. State, have any questions?
Just briefly, Deputy Kibler, the defendant asked many times if he was muted or unmuted. Do you remember that?
Yes.
Can you confirm that even on the occasions when his microphone was muted, the audio in the courtroom continued to work?
It was.
And at any time while Mr. Brooks was muted, or even if you didn't know, at any time did Mr. Brooks ask to be brought back over to this courtroom, sir?
He did not. He is telling us he prefers right now to be in that courtroom. He did not want to come back in here.
All right, thank you. Those are all my questions, Your Honor.
Mr. Brooks, you are unmuted. Do you have any questions for this deputy?
No.
All right, thank you. You may step down. All right, then I'm going to have Zach Tremaine also take the witness stand. Do you have- I have it on my screen. Can you do a project it, please? Yes.
How embarrassing is it to have so many
All right,
adults
there
verify
is-
that you're acting like
First
a
of all,
child?
sir, stand and raise your right hand. Do you solemnly swear that the testimony you're about to give shall be the truth?
Zachary.
What is your position with the clerk of court's office here in Waukesha?
Oh, we got a
IT
clerk
coordinator
and
for
a
Washington
sheriff. So
Circle.
Bush, he's just
Were
entering
you
all
in
of the records.
courtroom 20 this morning following Mr. Brooks
Back to do
on the
overlaid on top of what we call the X panel. It is our
photograph that's
we came back to do a measurement of a DD meter later.
There's a document or a photograph that's displayed on the monitors throughout this courtroom. Can you tell me what we're looking at?
So my phone is in the photo,
meter.
overlaid on top of what we call the X panel. It is
And
Here's the times, either 9:26 or 9:36 a.m.
my
You are in the meeting now.
all right, so the record should reflect that
Whether you drop the meeting.
I've now changed the audio visual from the Polycom unit to the use of Zoom. I've called in both courtrooms and they can hear from over there, and then I'll get the email just a second, and then I'll share screens of the color.
Using technology now to
Images being displayed.
slow things down. Jeez, come on.
So that the evidentiary phase is supposed to be closed. How come I haven't been able to present my evidence into the record as I've asked numerous times on the record to be able to do? I've said I have numerous documents that needed to go into the record. Why have they not been permitted to be made evidence? I didn't rest my case, so I don't know why that's being closed.
Discovery.
And I have yet to be able to offer my exhibits into the record. for
You're
evidence.
supposed to submit
How's that
this stuff
so?
for discovery. You can't just make up.
So the court did
documents.
declare the evidentiary phase of this trial closed. I specifically found that you forfeited your right to present any further evidence or testimony when you failed to answer my questions regarding the calling of witnesses. And then I also declared that you forfeited your right to testify. Specifically as it relates to your trial filing, sir, I would note that all evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure and all rules of evidence. To the extent that you wrote all of those documents, sir, that would be hearsay. And for that reason, I'm denying your request to make them part of the record.
You can't just
And
create
not
documents.
hearsay, Your Honor. I did what you told me to do. You told me, since I was representing myself pro per, that I had to write everything out and present them to the court.
So that's not what I said, you're misquoting me, but in any event, I'm
No, that's
denying
what
your
you said.
request. I
So
said,
you're saying that I have no right to present evidence.
You
and to
had
have
the
exhibits
opportunity
as the
to.
state's been able to do.
Mr. Brooks,
Are
I'm
you
not
denying
going to
my-
have a debate about this
Are you
now.
denying-
I have,
are you-
I gotta
are you
mute you
denying
once
your
again.
right?
So, Mr. Brooks, I have muted you because I declared the evidentiary phase of this trial closed. You forfeited your right to present further evidence and
He took off the
testimony
headphones. Of course he did.
previously by refusing to answer the court's
And of course he's
questions.
yelling.
I will
Not
specifically address the filings. Number one, it is not true that I advised him that any filing would become evidence. That is simply false. Number two, filings, I told him if he wanted to present motions, should be written down and should be based in law and fact and request specific relief. I'm well aware that previously he has referenced he would like his filings made exhibits. I've reviewed those filings. There's nothing relevant, nothing probative, or the information contained therein is hearsay. Mr. Brooks would have needed to testify regarding any statements that he, from himself, testimony. He cannot simply put in an affidavit. That's not proper. That's hearsay. And he hasn't asked in any of those filings that he hasn't put forth any exception to the hearsay rule that would allow this court to admit his written filings. I believe, without fail, they are all irrelevant, not probative, and hearsay, and therefore not admissible. So we're moving on to the discussion of jury instructions. When Mr. Brooks wants to abide by the rules of decorum and civility, I will unmute him. He clearly just took the entire packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply put them under the table, but they are no longer in front of him. I will, however, unmute him so that we can get his feedback
Oh dear.
regarding jury instructions. It's typically a back and forth. We'll go through them.
Gonna regret that.
And I'll ask the parties whether there are any instructions they believe should be included, and we'll have a discussion on that, and then we'll talk about whether any of the instructions that are in here need to be modified in any way, taken out, edited, etc.
Beauty.
Right, you're unmuted now, but but you have to not interrupt.
Oh, you can't, I'm not trying to interrupt, but how can you deny me the chance to put on the adequate defense by saying nothing that you told me to do can be presented into evidence? So you filed them, you filed everything that I gave to you.
Right,
filed.
Mr. Brooks, I'm
And
going
that's
to
what I'm
mute you
saying.
because this is not relevant at this time.
It is.
He's raised tone of voice, he's very animated, he threw the jury instructions on the floor. I understand you're upset, sir. I understand you believe I'm violating your right to present a defense. I've made my rulings. I determine you forfeited your right to testify, which includes the right to present evidence as you would have testified. I closed off your ability to call any other witnesses by finding that you forfeited your right to do so based upon your conduct. I understand you're frustrated. I understand you believe that I'm not without authority to do that. I made specific factual findings. I referenced the law, and you being upset with the decision is not going to change my mind. He's also taken the headphones off. It's his choice right now whether he participates in this jury instruction conference. It is his choice. But if he is going to spout off about things that I've already determined, I will continue to exercise the mute function on the audio equipment. I'll unmute him again, but you are advised, sir, you need to be proper, you need to not interrupt, and you need to stay on task, which is we're discussing jury instructions, not other evidence, not subject matter jurisdiction, not your belief that I told you to file things a certain way. We are now discussing jury instructions. So once again, I'll unmute him to see if he can follow these simple rules.
You need to tell me why I can't present evidence. How can you deny me the fact? How can you deny me my right to present evidence?
All right,
I
I'll
told
unmute
you
him
before
once
this.
again because he wants to continue. And again, I understand he's upset. I understand that. But he has himself to blame for his conduct this morning and the rulings that I've made. All right, so let's go through these jury instructions. First of all, has the state received a copy
Fuck
of
yeah! You're
Thank
done,
you.
dude.
Mr. Brooks, do you acknowledge receipt? I believe you did by acknowledging it previously, but do you acknowledge receipt of the draft of the final jury instructions?
I didn't acknowledge nothing, and I don't acknowledge anything now. I have not received anything.
I would ask the bailiff to
I
pick
don't
up the
see.
documents from the floor and put them in front of him.
And
once
I'm
again.
not presenting it to nothing I don't give my consent to. You can't deny me the right to put on the defense. How can you tell me when I done stated
I'm gonna
3 or
read it
4
once
times?
again, because again, I understand he's upset. If the bailiff could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his forfeiture by conduct of his right to present further evidence on his behalf.
Thank God.
I know
Good
one
job.
of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment from the amended information on count 70.
What's he doing?
No, I don't want to do that.
What is he doing?
Hold on.
He's doing something.
70
What's he doing?
6, the 76 count, just wanna make, it says near Frame Park, so it is in there, but that was just one question I had.
He's doing something. What's he doing?
Alright.
Oh no.
So, state have any requests as it relates to jury instructions?
Your Honor, I'm just going through each one. I'm on page 50 of 107.
I
Everything's
have a
looking
hint
great so
of
far.
what he's
Okay.
doing, and
Fair enough, there's 107 pages, I certainly can give the parties some time to continue to read.
I didn't want to believe it was true. He built a, I wouldn't say a fort. He just blocked himself out. What, so the jury can't already identify you by how, like, literally everyone... Ooh, did you see those spindly fingers sticking out the side? Ugh. I'm gonna have to look at that later. God, those fingers. He's got those
Mr. Brooks is
creepy-
requesting to go back to his cell at this point, I'm gonna deny that request, he can remain in the other courtroom.
creepy fingers, man. Never mind. Oh, I've never seen anything like this. I have never seen anything like this in my life. And I mean, I'm not a lawyer. I do like to watch law, crime, and what's he doing? His head's moving a lot back. What is happening? What is happening?
I know he's with his lungs. I know he's muted, but I can certainly hear him from this side. He appears to be yelling at the top of his lungs. I can't decipher what he's yelling.
Oh, come on. Come on. Can we get
I'll
past
advise Mr. Brooks without a specific waiver of his right to be present, even if it's from the remote courtroom, he's going to remain in that courtroom. And that would require him to have a colloquy with me. I know upon my review, I noted a few spots that, either in the headings, have some information or words that might need to be removed.
I believe that was incorporated. I mean, usually it's a standalone instruction. I think the court incorporated it with the first degree intentional homicide because certainly that was.
I think that's part of the pattern instruction.
Oh, it is. Okay, then we'd ask for motive. I think that there's a 175 instruction that could be given as a standalone.
Yeah, I got requests. It ain't.
Get to the back of his chair. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table so
Yes,
we
I
can
think
see?
that's fair. I'm gonna advise the bailiff to remove the box so I can see Mr. Brooks. I don't know what he's doing behind there. He has quieted down. I haven't heard him in a while. If you could move the second one because it can interfere with the microphone as well. And the third. Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury instructions? Any requests for instructions that aren't included that you believe should be included? Any edits or deletions from the packet that has been provided to you?
Hey, why do you tell me to move my mic?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or otherwise?
Hey man, you don't gotta talk to me like that.
We're not
Do
playing.
you have any requests
First of all,
related
what?
to the jury instructions, sir?
Man, yeah, I got requests. It ain't like they gonna be honored though. 'Cause
As it
nothing-
relates to
nothing
the
I'm
jury
keep
instructions,
telling
sir,
you.
what are
I
your?
heard what the hell you said, man.
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Mr. Brooks, do you have any
I'm tired-
requests?
I'm tired of my rights being trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Ain't nobody understand why I'm frustrated. How you gonna sit up here and make decisions based on what you think I said when I didn't give consent for you to do any such thing?
Sir, I understand you may be upset, and I really do,
No, you
but
don't
I've made my
understand nothing.
determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't. Because
I'm gonna mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him 5 opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
Mr. Brooks, I know the audio is turned up. I believe you can hear me. You've chosen not to put the headphones on, that's your choice. My final question to you, do you have any requests as it relates to the jury instructions?
Final question.
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you're saying.
Then you should put the
What about
headphones
that
on.
Don't you understand? What about that don't you understand? Do you see headphones? You can see everything, you can see boxes, but then you see headphones.
Have you asked for headphones to be provided, sir?
I shouldn't have to ask for them. I asked for my boxes to be moved.
I believe they took them away previously because you were so agitated, they were perhaps afraid you might break
Yeah,
them.
I'm still agitated. I ain't gonna stop being agitated. That ain't gonna stop. You sit up here and do everything you're doing and think God don't see what you're doing? You ought to be ashamed of yourself.
Mr. Brooks, do you have any requests as it relates to the jury
Yeah,
instructions?
I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is
Yeah, I
it?
got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with
I bet the jury can't wait to go home and actually see what this guy was like when they got removed.
I'm gonna get one.
I hope they get to find it. I hope they get to see it. After they make the deliberations,
Worried about
obviously.
what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You been being disrespectful. You been being disrespectful.
I need to know what your position is regarding the jury instructions. And I need to know it now.
Now.
What you mean? Who you talking to?
I'm talking to you. I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpings when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
It's not double jeopardy. Your objection is noted.
double
It's
jeopardy.
overruled.
It is double jeopardy. How you gonna charge me with the same charge that I'm already charged with? You can't do that. The Fifth Amendment says that you can't place somebody in jeopardy of life and limb. Twice. I'm already charged with the same count in Milwaukee.
That's not how that works. That's not what that means.
It's the same bail jumping charge. So how am I charged with that here?
Sir, I'm not going to provide a legal explanation other than to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in jeopardy of life and limb twice. You can't do that.
What's your next?
The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out? You always want me to not interrupt you, but you always find a way to talk over me.
I understand your position. I'm saying it's overruled.
You always want respect. You always want respect, but don't want to give it. I'm charged with the same bail jumping charge. Can't charge me.
You're violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others.
Okay.
That's the distinction.
Again, there is no distinction. It's the same charge.
That's a big
It's
ass
the same offense. It doesn't mean it's the same factual basis, sir.
He is not charged with bail jumping with the data violation of November 21, 21 in Milwaukee County anywhere. Further, the double jeopardy prohibition would prevent him from being convicted twice, not charged twice.
All right, so we've addressed that, sir. What other requests do you have as it relates to the jury instructions?
I want to know why I'm even charged twice with the same thing. You can't charge me in pursuant to a.
That's not how that works, you dumbass.
That I'm already charged with bail jumping for. I'm already charged with bail jumping for that already. So you can't essentially say, oh, well, because you were already on bail, we're gonna charge you.
It's a different data violation, sir. The conduct for the bail jumping is related to the allegation that you committed a new crime in Waukesha County while out on bond from the Milwaukee County case.
Yeah, but I'm referring to the first bail jumping count. The first one. I'm not referring to both of them. I'm referring to one of them.
My understanding, sir, is there's different dates of violations as it relates to that. So I've noted your objection now repeatedly. I understand it. Your request to, I guess, dismiss the bail jumping counts are denied.
I didn't say nothing about count. I said one.
Well, there's one count or both, it's denied.
Doesn't matter.
Not being understood.
Fuck
They
off,
charged
dude.
with the same charge twice. You can't.
I have grit.
Charged with it. I'm already charged with it though.
This is a circular argument, sir. It doesn't change the fact that, from my perspective, the 2 bail jumping counts are going to proceed forward. There's been sufficient evidence presented to warrant the
Not to talk over you.
Didn't you just go, hey?
They can't.
There's been sufficient evidence presented to warrant the jury being instructed.
That right there.
They can't.
What other requests do you have,
You're not
sir?
gonna talk over me. Don't talk over me.
Brooks, what other,
The whole time you've been over there, you had me muted. I didn't see no requests over there. I'll agree. Both know that what you're doing is not right.
Mr. Brooks, I'm going to refocus your attention to the jury instructions. All of your objections are noted. I understand that. If you can't answer, all right, I'm going to mute him once again. He refuses to answer simple questions regarding if he has any requests. He just made an argument regarding the bail jumping, so clearly he has an understanding about the law as it relates to that. It may be a misunderstanding about the law and double jeopardy, but he made an argument. I've denied it. I'd like to know if he has any other requests. If he can stay on topic, I'll I will unmute him again, and he can tell me the list, just like the state went through a list. I need to get through their list. I'm asking you to list out all your requests, and then I will take each one up in turn. So here's your opportunity to give me your other requests, not debate with me about prior rulings. Go ahead, Mr. Brooks.
This is not gonna go well.
Try to play no games talking about you giving somebody an opportunity that you haven't gave me an opportunity to properly defend myself with evidence, with substance and evidence.
You're just being argumentative.
Before we even got to this.
We're way past that,
You
dude.
told me you wasn't in the evidentiary phase.
Mr. Brooks, do you have any other requests as it relates to the jury instructions? This is probably the 10th or so time I've asked you this question.
No, it's not. No, it's not. So please stop being incorrect, Your Honor. Please stop.
Do you have any additional requests as it relates to the jury instructions?
Yeah. That first count 74 bail jumping needs to be dismissed. You can't charge me with 2 things. You can't charge me with the same charge twice.
All right, I've made a note of that. What's the next issue?
Either one county gonna charge you with it or y'all, but it can't be both.
That's not how that works, you jackass.
Exact thing that I was gonna bill for. The same exact thing. The same exact case. So why are we giving the jury instructions on 2 cases from another county?
I've made a note of that. What other requests do you have?
Man, this is ridiculous. So I'm not even able to adequately defend myself, present evidence, do anything, because everything I say is gonna be.
That was your choice to forfeit.
What are we doing here, Your Honor? What is the
Mr. Brooks.
Why should I be here when?
I've made a note of your request as to count 74. Do you have any other requests as it relates to the jury instructions?
Why do we even have a jury instruction? Why do I have to even sit here in this courtroom at this point? Because everything you've been doing without my consent anyway. So you're gonna find a way to do this.
You
without my
don't
consent.
get to make
Why do I need
consent
to
for
be
the
here?
court.
Your objection for lack of
Court
consent is
does
noted
not
for the record.
revolve around how you.
Any other requests, sir?
You talk a big game. You talk a big game to save yourself enough space. But everything got put up that has no merit in your court. None.
All right, I've asked him many times. I've advised him, and I'll advise him once again. If he fails to answer the question, I'm moving on. Do you have any other requests as it relates to the jury instructions, sir?
You can't move on because I haven't given you consent to it.
All right, he did not answer. So I'm muting him again. The only request that he has made as it relates to the jury instructions, as he pounded his fist once again, raised his voice. I understand, I really do, that he's upset with my decision to cut off his ability to present a defense, but that decision was made based on his conduct and his conduct alone, as I've outlined already on the record. So the only request that he made was as it relates to the bail jumping counts. I'm denying those requests, whether it be to dismiss one count or to dismiss both on double jeopardy, or to just not instruct the jury.
You're gonna put on the headphones.
However way I interpret it, I'm
Oh.
denying that. All right, let me go
She
through
moved
the
on,
state's.
buddy. Yeah. Oh. Yep.
Sure.
Oh.
Sorry. 154 summary of evidence. I believe we had a map, actually 2 maps that summarized the, we had 3 maps. I think the one was summarized his route, the path that he took. The other one summarized the victims who were struck in the specific locations. And the other one summarized the positions of the law enforcement officers at the various intersections and throughout the parade routes.
I'll make a note of that. I don't believe I saw the jury view instruction either. I mean, that was given to them at the time. I don't know that it needs to be reread, but I think we need to consider that as well. And that was my version of 152.
He's gonna rebuild his wall.
All right, so let me go through the
You gotta
list
be kidding me.
from the state.
You gotta be kidding me.
Turning to
No.
page 61. So I've considered the request by the state. I am going to rely on what information they put in the charging document. I'm going to deny the request to include the specific case numbers. There's evidence, of course, that was received regarding the 2 separate cases out of Milwaukee County that form the basis for both of the bail jumping counts. It will be up to the jury to review the evidence and make a determination as to the verdict forms, though, that were referenced previously, at least the description of them in the jury instructions. That obviously the 3rd account of bail jumping is incorrect. That needs to be battery, and that change will be made. I'm also having Madam Clerk include all of the numbers for the jury instructions when they go back, so it's very clear. Some of them did not have them on, just frankly from prior cases that she and I have worked on, but in this case I want to be very clear with all of the numbers. So I think I've addressed the first 2 bullet points. As far as the motive instruction as a standalone, I believe that is appropriate, and I'll instruct Madam Clerk to include that. As influence your verdict in any manner. What's the state's position on including that, but taking out the paragraph you request to be taken out?
No question. Are you my accuser? Are you my accuser, Your Honor?
All right, he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this. I agree with the state. I don't need to highlight that second paragraph. I will take that out, but I will include in the paragraph that reads, at times, comma, Mr. Brooks has appeared from another courtroom, period. This must not influence your verdict in any manner. On the last couple of pages, and the part about juvenile adjudication should be struck from the heading or more. Request he should, he is currently muted. He can raise his hand and I'll unmute, and then I'm going to assume he's. Then 141 is an issue. To take that out. Is there a request from you, sir, to take 141 out? I'll unmute for that purpose. It's found on page 106 because it's at the end of the instructions. This is the instruction on identification of the defendant and where it's at issue in a case. I believe it's appropriate given the testimony in this case.
Even paying attention.
Do you have any position on that, sir?
Even
You are unmuted, so you can simply answer yes or no. No response. Then 172, circumstantial evidence during this case.
So how long before you mute? As soon as I say something?
Depends on what you say, how you say it, and if it's responsive to what we're doing.
Why do I have to be responsible to what you guys are doing? Nothing I say even matters at this point, so what's the point of me being responsible? You can't make decisions for me.
Mr. Brooks, I'm gonna mute you unless you can participate in what we're doing, which is discussing the jury instructions.
I'm gonna tell the jury the truth. That's what I'm gonna do. I'm gonna tell them what hasn't been told to me.
You already
Mr.
missed
Brooks,
that.
I'm gonna mute you because we're trying to discuss the jury instructions, not what you're going to say during your closing argument. I will get to that later. In terms of instruction 172, I'll instruct Madam Clerk to take out of the heading the word escape.
Man, I can't wait. Oh, closing arguments. I can't wait. Are you kidding me? Oh my God. That's gonna be great.
Then I've reviewed 154. I believe that's appropriate.
Unless he's just gonna break down and
I'm
cry
gonna pull it up
like he
just
did
as a
at his
draft. I'm not sure
opening
if there's anything that
arguments.
needs to be.
Boy, I really hope.
Or modify that in any way based on the evidence submitted,
And the associated counts, I believe,
wasn't it?
and there were some charts of the extreme.
Yeah, dude, he gave them so much extra work.
But
Things that they
Everything
had to
154 should not be given,
that's what I was wondering.
because
So,
they were all.
these last issues that we've discussed with, as a,
Make sure the record is correct. You took a 10-minute break,
I did.
at which time I was brought back into this courtroom.
I was advised you wanted to stay, sir.
Okay, and you've been forcing me to come over here from the get-go. Why couldn't you force me to come back over here where I'm supposed to be at?
Sir, my understanding is you requested to stay in the other courtroom. I thought I put that on the record at the beginning. If I did not, I'll make that part of the record now. I was advised by the bailiffs that you were requesting to stay in that courtroom. I certainly advised you prior to that if there was a time you wanted to come back in, all you needed to do was ask. You've done that previously.
Yeah, but
And even during this time though, you've been incredibly disruptive.
I can't say that.
At one point you
We're
were muted
right
for
now
an
on
extended period of
speaking.
time and you were yelling so loud, sir. We could hear you in this courtroom. I couldn't decipher what you were saying. And I was also made aware that another branch could hear you. So you continued your
that's
disruptive
fine.
behavior.
That's fine, because at the end of the day, I should be heard. I have the First Amendment right to be heard. So if I'm gonna be constantly muted, the only way for me to be heard is for me to raise my voice.
Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to improve them. I'm going to take a break and then we'll come back in the afternoon to go over verdict forms.
I didn't answer yes or no, so how do you consent to anything without me answering the question?
Are you going to answer the question, sir?
But you can't force me to do it though. You can't just say, I'm gonna do this because.
Sir, but you also can't stall the proceedings by failing to answer.
I didn't try to start the proceedings. You the one that held me in contempt.
I never held you in contempt. All right, I'm going to mute him once again because he refuses to answer a very simple question about whether he has any requests as it relates to the jury instructions. I will work on making all the changes with Madam Clerk, finalizing the order, print them off again. She has been working on the verdict forms, which are of course separate, which need to be approved by this court. So those will be printed off. A set will be provided to the state. A set will be provided to finalize the verdicts.
Alternates and those.
They know that. The parties make their of the. All right, we are in recess until 1 o'clock. I have instructed, and Mr. Brooks is present in this courtroom. Prior to the, I understand your objections noted.
Jesus.
If you would like to go back to the other courtroom, sir, you may, but that is a choice that you would be making. I am not requiring you, I'm not forcing you at this time.
So you're not holding me in contempt?
Sir, I am not requiring you or
We're like 3 seconds
you
into after
to go
lunch,
into
man.
the other
Come
courtroom.
on.
It is a new part of the day. I thought it appropriate to have you brought here.
Why?
And only if you forfeit your right by conduct will I put you back in the other room.
So you gonna address subject matter jurisdiction for the record, or are you gonna state it on the record?
Here we go.
I'm declining to, of which
The record. You
your
have to state
objection
it
is
on the
noted.
record.
Mr. Brooks, I do want to go over
We don't
the
have-
jury instructions.
and I'm not going to participate in something that I don't understand.
That's your choice, sir.
May I please go back into the other courtroom?
You can, based upon your present in this
I didn't forfeit
courtroom.
anything. I asked.
I understand.
But based upon what kind of me asking? I'm not going to expressively waive anything.
Are you willing to
I'm making
engage in a colloquy regarding your right to be present in a no way?
I don't understand, and I will not answer any questions that I don't
That's the
understand.
thing, you
I'm
don't
making a
understand,
request
and
to
yet
not
you
be
chose
present
to
in
represent
these
yourself.
proceedings.
This is why.
And to
This
be in
is
the-
why you're advised not to represent yourself, because you are not a professional. You're in a room of people who are professionals, and their job is to win. Or to be a referee. And if you're failing, losing dramatically, it's probably due to your own lack of competence.
in their courtroom.
Again, as I've stated numerous times now for the record, I will not answer or comply with anything I do not understand. I'm not making a voluntary waiver
You're
of
boned.
anything.
You're boned.
Are
See
you
ya.
willing to be, let me rephrase that. If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand the
I
question.
don't
you're asking.
understand. He doesn't
Are
understand
you
that.
willing to not interrupt the proceedings with disruptive behavior?
I do not understand the questions that you are asking.
Well, given that he won't answer the questions directly, for now he is to remain in this courtroom.
I'm requesting to not be in this courtroom.
But you won't answer my questions regarding that, sir.
I did. I told you I don't understand.
That's not answering the question, sir.
You asked me a question, I answered it. I don't understand. How can I answer something that I
There
start
is
with?
one I
You
would
start
like
with subject
to-
matter jurisdiction?
No, please do not interrupt me again with the topic of subject matter jurisdiction, or you run the risk of forfeiting your right to be present in this courtroom.
Then let me go in the other courtroom then.
Are you willing to engage in a discussion about that, sir? I need to make an appropriate record.
I just told you that I don't understand the questions you're asking. What do you want me to do? I can't answer something I don't understand.
I believe you're choosing not to answer them,
You can
sir.
believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so.
Your
But it
right
doesn't
to
matter
be
what we
unfettered,
believe,
sir.
Your Honor. I'm merely stating a request to not be present for these proceedings. I cannot answer the
Sir,
questions you are asking me
it
because I
seems to
don't
me
understand them.
You understand your right to be present in the courtroom. Are you telling me you
I don't understand
that right?
anything. Nope, I don't understand. Nope.
Then you're gonna stay here. For now.
And under what lawful law? You can't force me to stay somewhere that I'm making a
United
request not to.
States,
You
who
can't,
is
you
lawfully
can't make me
given
understand. You can't force me to understand what I don't understand.
to
You
these
can't force
five-
that.
I need to address one of the jury instructions, number 315.
So, Your Honor, I'm trying to make a request to not be present in these matters without disrupting the courtroom, as you say that I do, and over talking you, as you state that I do. I'm making a request merely to not be present for these proceedings. Obviously, I'm not needed because every decision that's been made here today has been made without my consent. That's clearly telling me that I'm not needed. I have never consented to anything that's going on here today. I haven't even been allowed to present any evidence, which is something that I stated weeks ago. Weeks. You already knew, Your Honor, that I wanted things to present into evidence. I've asked numerous times for that and have been denied. And I don't understand why I'm not being able to adequately defend myself.
In your words, you're not being allowed to adequately defend yourself based upon your conduct in this courtroom and throughout these proceedings, and your unwillingness to follow the simple rules of decorum, courtesy, procedure, rules of evidence. You refused to answer a variety of questions this morning when this court went through or attempted to go through the colloquy with you regarding your right to testify and your right not to testify. And because of that, and based on the case law that I cited this morning, I made a finding that you forfeited your right to present further testimony and evidence through other witnesses, and then you forfeited your right to testify in your behalf. I'm not gonna revisit those, sir.
He
I'm
doesn't
not asking you to
understand.
revisit them. They weren't correct
I don't think he
I understand
understands.
you will
because
disagree
I
with
never
that.
consented to it and I never answered something.
I understand
I
that.
just stated the reason why I
Your
didn't answer it because I
consent
don't
is
understand.
fucking
You cannot
irrelevant,
force
dude.
me to understand what you're asking me.
Sir, I could not even get through the advisement. You wouldn't even listen. You talked over me repeatedly.
Was that from the other courtroom or in here? Because I've been over there all morning.
To the place that you are requesting to go back to, right?
You sent me into the other courtroom.
You're right, I did.
Right. So I've been over there all morning.
With an adequate audio and visual system
I mean,
connecting the two courtrooms.
Your
The functional equivalent
to
of being
your
present in this
equivalent to
courtroom.
your equivalent is adequate, but to mine it's not. Seeing as how you always state Illinois versus Allen. You always state that. You always state that. But it never refers to a fourth option that you refer to. It never
Mr.
refers
Brooks, I'm not
to
going to
it.
debate this with you. If you continue to bring up subject matter jurisdiction, Illinois
I
versus
didn't bring up
Allen,
subject
the
matter
decisions that I
jurisdiction.
made earlier,
I'm trying to figure out
then
why I'm being
you
held in
are
contempt.
frustrating the purposes of this
I'm
hearing
trying to
right
figure out
now,
why I'm being held
which
in
is to
contempt.
finalize the
And
jury
then when I-
instruction and the verdict forms.
Your Honor, I'm merely trying to understand why when you hold me in contempt,
I never held you in contempt, sir.
you attempted to.
Nope.
You've never attempted to hold me in contempt.
No, sir. Again, I'm not going to revisit all of these issues.
When I asked you where you hold
Are
me in
you
contempt,
going
you
to
said civil.
respect the decisions that I've made?
They're
by
not
not interrupting
they're
me?
not correct decisions, Your Honor.
I understand that.
I can't answer. You asked me questions. You asked me questions. I didn't answer them based on my understanding. How can you force me to understand what you're asking me if I don't? And then you still make a finding based on that. How is that lawful law?
Mr. Brooks, I stand behind the record that I've made today.
And that's fine. I'm not
I'm advising you
arguing
that
with
if
you
you
about what you
continue
rude.
to talk
I'm saying
to
how
me,
can you do that without my
If
consent?
you continue to raise issues that I've
That's
already
a violation
addressed,
of my civil rights.
if you continue to raise these issues, sir, and thwart the purpose of this court, which is to finalize the jury instruction and the verdict forms, you will forfeit your right to be present in the courtroom, and you will appear from the other courtroom.
Okay.
Absent you, I know
And
you've requested to
I
be
just
there.
made a request the moment we walked in here to not be present for these proceedings, but yet
But you
still.
also won't have a dialogue with me about your understanding
Because
of what that
it's my
means.
Fifth Amendment right. I'm exercising my rights that I reserved from the moment we walked in here this morning. You can't force that. You can't force me to do anything. Actually,
Yes. Actually,
No,
she
you're right,
can.
but I can make certain findings that you forfeit rights
you
that
can't.
you have based upon your
based on
conduct.
what lawful law you're on?
I've cited the law this morning. All right, I am moving
Illinois
on.
versus Allen, right?
I am
That I
moving
could be
on.
present from another courtroom.
I need
if I
to
forfeit
discuss
my right-
instruction 315.
Your Honor,
because
I don't
believe some
understand.
language needs to be
Christ,
modified
this
based
guy
upon the
is
court's
so-
earlier ruling today.
I don't understand. I don't understand the proceedings,
Well, then you should have hired a lawyer.
and I think that should be stated for the record.
Yeah,
If
you
I'm
should have
telling
hired a lawyer.
repeatedly, Your Honor, that I don't
Actually, I
understand.
think everybody knows
You
that.
can't my constitutional rights to try to force something upon me. That's coercion, Your Honor.
Morning. While it is true that you did not provide consent, you were entirely
didn't.
uncooperative with court this
That's
morning.
because
The
I'm
questions.
the way that you're making it seem is that I intentionally didn't want to answer, and that's
Mr.
not
Brooks,
fair to proceed.
Mr. Brooks,
If I'm
please stop interrupting
and for the record,
me.
I don't consent to being called that name,
You
Your Honor.
clearly, I know you can hear me, sir. I'm asking
Hearing
you
and
to
understanding
stop
is two different
interrupting
things.
me.
I'm not trying to interrupt you, but you're gonna at some point you're gonna ask me my opinion of what's going on, and then when I tell you I don't understand, it's gonna be taken as me trying to delay or trying
If
to
you
do this
stop
or trying to do
talking,
that,
I will explain why I'm bringing up instruction 315.
and I'm not gonna understand your explanation.
Well, you can't say that if you haven't heard what I have to teen, which is the instruction that has the that instruction made to testify. I believe it would not be proper for this court to include 315 in the instructions to the jury. Does the
She's
state
still
have any
trying to
position on
protect him.
that?
She's
Your Honor, I
trying to
did
help.
look at the notes that are associated with instruction 315, and I would agree.
Mr. Brooks, do you have any position on whether this court should include instruction 315
I don't
in the
understand.
jury instructions to the jury?
I don't understand, so I don't
understand
consent.
With 315 jury instruction.
By as the manner.
What do you mean my silence? My Fifth Amendment right?
Correct. I'm not hearing a request from you to have the jury
Because I
given
don't,
this
I
instruction.
don't understand why you're asking me the question, Your Honor. I never.
Are you
never
hire
decided
a
to or
fucking
not to testify.
professional?
Never
I
decided
understand that,
either
sir.
way.
I understand that.
So how can I answer that? I don't understand why. I don't understand.
We are now at the moment where we are discussing whether the jury should receive an instruction specifically on you not testifying, irrespective of the reason for that. I believe I could modify this instruction to simply say a defendant's silence or a defendant not testifying should not be considered by the jury in any way and must not influence their verdict in any manner. Are you making such a request for a modified instruction?
I don't understand the question because I never decided to or not to testify.
I
Never
understand.
said.
I understand what you're saying, sir. I really
You
do.
did decide
But in
not
light of
to
the court's decision
testify.
that you forfeited your right.
You absolutely decided not to testify because you would not shut your fucking mouth. She gave you every opportunity to testify and you would not shut the fuck up. And so you forfeited that right. That's how that works.
To testify.
How did I
Do
forfeit
you
something I
want
never
the
said?
jury to be instructed something to the effect
I didn't
of
consent
they
to
cannot use your
forfeit.
silence, meaning they cannot use
You
not
did.
testifying against you in any way?
100%.
I don't understand because I never made a decision not to or to testify.
I'll ask you one more time, and if you do not answer with a yes or no, I will take your answer of not answering as you are not making a request for a modified instruction.
How can you do that,
Do
Your
you
Honor?
want this court, sir, to instruct the jury in any way regarding you not testifying in this case?
I don't understand the question.
All right, then based
I don't
upon there's
understand.
not been an express request made by Mr. Brooks to give either 315 as it's in the standard or pattern jury instruction, or a modification as this court has suggested, 315 is to be taken out of the jury instructions.
How are all these decisions being made without me understanding?
Then I have looked over the verdict forms, and other than really what I would describe as inconsistency in how phrases, whether there's all caps, not all caps, but
All caps.
what we call the sentence
Like the name that was
capitalization
on
for
there,
the
all
charges. For example, I want to be consistent with how I spell out first degree intentional homicide or first degree recklessly endangering safety. There was just sometimes it was capitalized, sometimes it wasn't. So we're looking through all of that to be consistent. Want to make sure the word information is capitalized since that's the charging.
I don't understand. So I keep telling you I don't understand these proceedings, and you just keep running right over my rights like you don't even hear me saying anything.
Like you ran over the other people's legs! Holy
Go to the other courtroom,
shit.
please.
Are you
No.
waiving your right to be present in this
No.
court?
I'm not waiving anything.
Then the answer
You
is no.
don't
making a request.
get.
Then the answer is
No,
And how's it,
no.
so what? You gonna try to force me to interrupt and do all this so you
I'm
can
not
make the
forcing you,
record
sir. I'd
and
like
make
you
it
to be
seem like
here.
I forfeited something that I came in here as soon as we got on the record and made a request to not be present for these proceedings. But when I'm making a request to avoid the drama and all that,
Sir, the only one with the drama is you.
it's you too. You the big contributor to the whole thing.
Mr. Brooks, I have to preside over this case. I
Yeah,
have
and
to
you haven't
make
been
determinations.
impartial or fair yet.
Mr. Brooks, I have a question to the state. I ask that you not interrupt, and then I'll
It's
start
not
with
about
a
me
response.
interrupting. It's about me attempting to understand. I've been saying that since we came in here.
Mr.
We're not
Brooks,
here
I
to-
will-
You can't-
I
you
will
can't force
respond
me to
as follows
understand.
that.
We're not here
You
to
waived
teach
your
you.
right to counsel.
I didn't waive my right to no counsel. I
You
gave you the
waived your
contract.
right.
I did not. And you won't sit here and say that for the record because that is not
No,
what happened.
you are
No.
incorrect.
So we don't have it. Do we have the
You are-
paperwork? Because I believe that I gave you the paperwork back that you.
Mr. Brooks, you
I
very
gave it to you. Altered.
clearly
It did not waive it.
have been presenting a nuanced argument regarding
That is
the
not
right
true,
to
Your Honor.
counsel
That is not
versus
true.
the right to assistance of
That is
counsel.
not true.
That's a pretty sophisticated argument. That's why I believe you fully understand what's
I
going
don't.
on in this courtroom.
I don't fully
I
understand.
disagree with your characterization
disagree with your
of the
characteristic.
right to counsel.
You know that you accepted
You
the way that I
waived
gave it to
the
you. So
entirety-
you shouldn't have did that if you had questions of me not understanding.
I don't have any questions
You
whatsoever.
definitely do, because I'm telling you right now I don't understand, and you still won't even acknowledge the fact that I'm saying in open court on the record that I don't understand something. I haven't waived anything. You
Not
made
here to
decisions
teach
today
you. Not here to
that I
teach
didn't
you the
consent
law.
to,
I'm
that I
here to
explained I did not answer
enact.
because I didn't understand, which is my right to say that.
Right, Mr. Brooks, you
It's
are
also my Fifth
interfering with
Amendment
the
right to be
proper and
silent.
orderly administration of these proceedings. I understand that you disagree with the decisions that I have made, but you aren't respectful of the decisions. You keep wanting to debate them and argue them. That is not the proper legal recourse at this time. I have asked you if you're willing to waive your right to be present. You indicated you're not,
Because
and
of the
yet
way
you continue
put it,
to
you said
interrupt.
waive. I'm not waiving anything.
Then that's why you're here until I make a finding that you, by your conduct, are forfeiting your right to be present.
Well, make the finding and kick me out. Make the finding and hold me in contempt, which is what you're waiting to do anyway. That's why that courtroom been set up the way it has for the whole time, because at some point it's anticipated that I will be over there. Which is not impartial and which is biased. It's judicial misconduct.
That's not a proper characterization of that situation at all,
Stated
because
from the beginning, sir, that the goals of this trial.
So you reading from
Are
the paper, or
threefold.
are you reading, or are you just citing what you
Number
know?
one, sir,
He's not gonna
is
shut
during
up.
the evidentiary phase of this was to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process.
And I offered
That
evidence that you
includes
didn't allow.
developing relevant facts upon which a determination of guilt or innocence can be made. What is sometimes referred to in the case law as the ascertainment of truth. There's an equal but secondary purpose related to efficiency and effectiveness. That has been my repeated use of 906.11 is what that would fall under. There's a third goal of everything that I've done here, and that is the courtesy and decorum in this courtroom, what I've sometimes referred to as civility. Of course, there are other goals as well, including protecting your rights, protecting the record, protecting the jurors.
How have my rights been protected, Your Honor, if I can't even put evidence into
Disagreement
the...
with the
I can't
court
even admit evidence.
decision. But sir, you have not been willing to follow the rules of civility
But
and
that doesn't
decorum,
have
Mr.
anything
Schreier.
to do with my evidence.
It has
I could have
everything.
did that from the other courtroom too, correct?
Everything.
Sir, you.
If I
by
can be
your
present from the other
conduct-
courtroom, I should be able to present evidence from the other courtroom as well.
And you, by your conduct this morning, sir, are
I'm
not
saying-
willing to
I'm
answer
saying-
the
I'm
most
saying
basic of
totality.
questions
The
about
totality, Your
whether
Honor. The
you
totality.
had
Have I
a
not
witness
asked?
available.
Have I not asked? In fairness, have I not asked to admit evidence? Have I not asked more than once?
Mr. Brooks, you have not asked to present any evidence
Yes, I
in a
have.
legally
You told me we weren't at the
cognizable
evidentiary phase.
manner.
How would I know that if you didn't answer
And you,
answer the question?
as your own attorney, you proceed at your own peril sometimes.
That
Whether
has
you have a
nothing to do
full
with me
understanding of the
presenting
rules of
evidence.
procedure and rules of evidence or not. And
That
I
has
made that
nothing to do with me
abundantly
being able
clear.
to present evidence.
So, Mr. Brooks,
Nothing
Yeah.
I-
This is your
nothing I
final
presented
warning.
has been
Yes,
able to
it
be
does.
admitted into
I am turning
evidence.
to the state for make a finding.
Courtroom, this
Good, I did ask your
this is
clerk.
ridiculous.
All right, he's interrupted. He's forfeited his right to be here. He's chosen to do that despite the warning from the court. Will be
There
in
wasn't
recess
no
until
warning.
it's
I'm the
taken.
one that-
Forfeited his right to be here.
Good, I did.
Let me go.
Attorney Basie, go ahead.
Just let me go.
From the neighboring courtroom.
You want me to appear?
Finding that you forfeited your
Make
right
the
to
fi-
the forms. If you interrupt me or them again, then I will make a finding that you forfeited your right
Make the
to be
finding.
present,
Make the finding.
and you will appear from the neighboring courtroom.
You want me to appear from the neighboring courtroom? Let's just.
I don't.
Just let me go.
Attorney Basie, go ahead.
Just let me go.
I felt that all the verdict forms looked good. I did ask your
This is
clerk.
ridiculous.
All right, he's interrupted. He's forfeited his right to be here. He's chosen to do that despite the warning from the court. Will be
There
in
wasn't
recess
no
until
warning.
it's
I'm the one
taken
that asked.
over
So let's
to the other
make the record
courtroom,
correct.
and we
I'm the
have
one
the
that asked when
audio
we came in here, Your
and
Honor.
video working
I
appropriately.
asked when we came in here to
Madam
be
Clerk,
present
we'll
from the
have
other
to do it
court.
by Zoom because we may have to utilize the share screen in order.
We don't have to utilize no serious screen because I'm not going to participate in no proceedings that I don't
The
understand.
documents.
I told you I don't understand
We're in
a million
recess until
times.
we get the courtroom set up.
No, we don't have to be in recess. I don't agree to it.
Oh, my dear God. Hey, you guys, let me know what other crazy people you find in court, because this is about the best thing I can find to do is cover some of this shit.
Into the record from this morning, I had made a statement that, given his demeanor, the headphones had been taken off the table by the bailiffs. I was incorrect. Mr. Brooks handed the headphones to the bailiff, saying he didn't want to break them. All right, so we are discussing the verdict forms. Go ahead, Attorney Basie, you can complete your record.
All the verdict forms look good. I did notice, I think it was actually the day that it was speed. For count 15, I have a not guilty verdict. I did not have a guilty verdict, but the way that it was on the paper made me believe that something happened, and I think you probably have it with your packet, it just didn't get printed off for me.
Brooks has been muted. I am going to unmute him right now. And I should state again for the record, all of the verdict forms, or at least the drafts, were provided to him prior to the lunch break.
Oh, yeah.
Do you have any position on the verdict form, sir?
I wasn't provided with anything, and if I was, I accepted and returned it for value. And since I'm now in another courtroom, are we going to address subject matter jurisdiction? We have yet to prove it for the record.
All he's going to talk about.
Mr. Brooks, you were provided with the verdict forms. What you did with them, I don't know.
Again, I haven't been provided with anything.
Forms were provided to him on his table. Special verdict questions. Those special verdict questions are only as they relate to have that special verdict, and then the hit and run counts have the special question related to, did each of the counts involve the death of a person, and it names the person alleged to have been killed. So those look to be all in order. I've already addressed, going back to the jury instructions, it is my practice to read through all of the instructions up until the point of closing arguments, and then I stop. Parties are given their opportunity to argue the case to the jury, and then following that, there are what I like to call the closing instructions, or which are still quite lengthy in this case, given that they go through the verdict forms specifically. And then, of course, the alternate jurors would be selected. But given,
Am I muted?
no, you're not. You haven't been.
So I got a question about the enhancement for use of a dangerous weapon. How's that being charged? Is that under 939.632?
It is in the charging document, sir.
How's that being charged? From my understanding, that the statute reads the increased penalty provided in this section does not apply
if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge. Without the vehicle, there is no crime. So that would apply. So how am I charged with?
State one
Rather-
is your argument only as it relates to counts 1 through 6 or others?
Whichever count has the enhancement penalty for use of a dangerous weapon.
Well, that would be all of the intentional homicide charges and all of the first degree recklessly endangering safety charges for counts 1 through 67.
So 1 through 67.
Correct. I can have the state respond to that.
Yeah. How is the alleged defendant being charged?
So are you asking how, or are you making a specific request as it relates to the special verdict question?
I would say both. Seeing as how I don't understand how.
You don't understand. That does not help your
That's why
case.
there's the question.
Are you referring to again?
It's ready.
I believe you're referring to sub 2. Using or threatening to use a dangerous weapon is an essential element of the crime charge.
Charge.
Response?
Using, possessing, or threatening to use a dangerous weapon is not an essential element of either first-degree intentional homicide or first-degree recklessly endangering safety. If it were, it would be one of the elements in the standard jury instructions, and the defendant can see it is not. This is different from a situation like armed robbery, which does require the use or threatened use of a dangerous weapon. So the penalty enhancer is correctly charged for those two types of crimes.
Any final argument on that, sir?
Yes. That's not what the statute is clearly saying. It's clearly stated. It does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge. If there's no vehicle involved, where is the crime? It has to be an essential part of it to even be a crime. The alleged defendant is charged with using a vehicle to commit these crimes. If there's no vehicle, where's the crime? So it has to be an essential element of the crime. Otherwise, there's no crime. I think it's the essential element. You just walk up to someone and quote unquote has to be something used essential without the where's the crime?
The elements for intentional homicide and first degree recklessly endangering safety, neither one of those crimes have as an element in it use of a vehicle. There are certainly many different ways. So
That's the same argument in this, Your Honor. You can't have this alleged crime without the use of the vehicle. It's the same thing.
it's not an essential element of either first degree intentional homicide or first degree recklessly endangering safety. So
I respectfully object to that, Your Honor.
understood. Do you have any other challenges to the verdicts you'd like to raise at this time?
Stop watching TV, dude.
Yeah, will my objection to that be noted for the record?
It is.
May I request a legal reconsideration of your ruling, Your Honor?
Denied.
May I request a written finding of fact for your ruling? Your
No,
Honor?
that's not how that works, man.
Just for the record, it's my understanding that the verdict forms were put in the garbage by Mr. Brooks and they remain in there. That was provided to me by the bailiffs.
May
That
I
information.
respectfully request a written judicial finding of facts and conclusion of law record? May I respectfully move for interlocutory declaratory appeal to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Your request is denied.
I just read a statute that it came from. My argument was based on a statute, a Wisconsin statute.
Your request is noted. Your objection to the court's finding and determination is noted. I decline to issue any type of written decision or stay pending appeal, noting there is no appeal that has been filed.
May I let the record show that this court will not allow the accused to adequately defend themselves in this matter?
The court's already made its findings regarding the forfeiture of right to testify and the forfeiture of the right to present additional evidence and testimony.
Which was not
I'm not going to
justified.
I understand.
What I stated was I didn't.
Regarding the verdict forms, answering those decisions I make is I'll ask you once more.
That you are asking.
Sir, do
So
you have
I would-
any other issues to raise with respect to the verdict forms?
I do not understand the questions that you are
He
asking.
has now and will be taken by this court as a no. Sir, do you have
Under
any
what law of
additional,
fact? Under what law of fact can you say no? when I'm
sir, do
telling
you
I
have
don't
any
understand?
additional issues to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
answer with a yes or no. Therefore, this court takes that as he does not have any additional issues
That
to
is-
raise with
that is
respect
incorrect.
to the
That is
verdict
incorrect.
forms.
That is incorrect. I stated I don't understand. You can't force me to understand something, Your Honor.
All right, did the state have any
It is-
other?
it is my
I want to mute him
constitutional right.
momentarily.
It is
Mr.
my
Brooks, I'm muting you
constitutional
because
right.
I'm moving on to another topic. I
me
understand
hear.
you disagree with the court's rulings, but you need to respect the rulings with proper etiquette in this courtroom, which you are demonstrating once again you're not willing to follow, so I exercise my ability to press mute. Does the state have any other requests as it relates to the jury instructions? I want to kind of full circle back to that because I do need to approve of them.
Yes, we do not.
All right, Mr. Brooks, I'll ask you the same question. I will unmute. Do you have any additional requests as it relates to the jury instructions?
Yeah, I have questions related to all of them because I don't understand any of this.
My question was not, do you have questions, but do
And
you have
my
any
answer
requests?
was, I don't understand. And I've made several requests.
The requests are not related to the jury instructions, which is the phase of this hearing that this court is attempting to conduct with you and give you the opportunity to fully participate. Mr. Brooks is
You did
choosing
not.
not to answer my questions.
You did not.
I'm gonna mute him momentarily, sir. I will request at this point as it relates to the jury instructions.
And I just said before, I said I do. I said I don't understand the questions. Of course I have questions if I don't understand.
Sir, do you have any
That's common
requests
sense.
for any additional instructions that are
Yes.
not included or to remove any that are included?
Yeah, remove them all until I understand. Or ask,
Computer's not working.
oh, now the computer's not working.
Simply filing something with the court does not make it evidence during the evidentiary phase of a trial. There are rules of procedure and rules of evidence that govern that.
And you told me to make all my filings in writing.
Sir, I said if you had a motion, it needed to be put in
All those
writing.
were motions. All those were motions.
Sir, what filing are you referring the court to?
Look through all my motions.
Sir, it's not my job to advocate on your behalf. If you have
I didn't
something in
ask you to
particular,
advocate on my behalf.
Sir-
I asked you to do your job.
sir, if you have something, a specific request, now is the time to
My
make
job
it.
is not to do
Well,
your
how about
job.
this? I don't accept none of those jury instructions. I don't accept any of them. Any of them. And again, I'll tell you, I don't understand. Why do I have to keep saying this? When it's clear that I don't understand.
Spindly fingers. Ugh.
Your Honor, I can inform the
Gross.
court that jury instructions were due, I believe, on August 30th. The state submitted their proposed jury instructions as well as the substantive instructions, and the defense indicated that they agreed with our filing. So I don't believe that there's ever been a request for any different jury instructions than what have been filed with the court.
So what jury instructions are you referring to, or what document is being referred to?
You don't know what the fuck you're talking
on
about.
the defendant's behalf? Because, as we all know, I didn't obtain the discovery in full until the end of September. So there was
You're out of your
documents
depth,
that I didn't
dude.
even know.
Out of your depth.
Mr. Brooks, one final time. Do you have any specific requests as it relates to the jury instructions other than your request that they all be struck?
And I'm telling you, Your Honor, I don't understand the question. I can't.
All right, then I will take his response that he does not understand, that he does not have any additional requests.
I didn't say
And
that.
they will be
I said I don't
approved.
understand.
They will be
You
approved
can't-
and are,
no,
I'm gonna have to mute
no.
him. They are approved as, been drafted by the court and
No,
modified
no.
during the jury instruction conference on the record this morning and this afternoon.
Get rid of this
I will
guy.
once
We're done.
again review all of them just for grammar, just to make sure all of that is correct. And provide a written printout of the final draft for the parties before we break for the day today. I am also approving of the verdict forms that have been previously submitted to the parties, just noting there's just a few grammatical things that need to be corrected, but the content and substance are there, and I've already addressed on the record any requests by the parties this afternoon.
No, Your Honor, I believe that the final copy that we've been working off of is appropriate.
Any comment about that, Mr. Brooks, or any statement?
I don't consent to being called that name, and I just told you I don't understand these jury questions. I'm not going to know how they allowed to pass just because you feel that they should. When I'm telling you I don't understand them.
I would note
None
that
of
his,
those, not one of those jury instructions came from me, not one. How's that fair?
Mr. Brooks, this court gave you the draft
didn't
of the
give me
jury
anything.
instructions. I need to mute you because, once again, he's debating about things that I think are very clear on the record. This court provided both the state and Mr. Brooks with a written printout, 107 pages long, of the jury instructions it was considering in this case. We had a discussion this morning. We continued that discussion this afternoon. Prior to breaking for the lunch hour, all of the verdict forms were printed off and provided to both the state and to Mr. Brooks. It is also true that when he was previously represented by counsel, the court had some specific deadlines related to jury instruction proposals, and the state reminded me that there essentially was not an objection raised regarding the proposal and the filing from the state. I had a brief opportunity to look through the record of the inmate communication forms that have been sent during this trial that are on file. I haven't seen anything that references jury instructions. I'm well aware that he has other filings, but I could not find anything related to jury instructions and any specific request that he is making or made during this case. So for the record, I am approving of the verdicts, I am approving of the jury instructions, and once again, before we break for the day, I will make sure to provide the parties with written printouts of both of the documents as they now stand. Then there are a few other issues we need to go through. Attorney Basie, I think you brought these up prior to the break. It was Attorney Opper. Address. You are unmuted. I am.
I just told you, since nothing I say even matters at this point, I'm just gonna tell the jury what they need to know. I'm just gonna tell them the truth.
Mr. Brooks, you are aware that your closing arguments have to be based on law and fact, correct?
They're gonna be based on whatever I'll base them on.
Well, I trust the state will object when appropriate,
Well,
if
It's
appropriate.
gonna be a whole lot of objection then, because I'm gonna tell the truth. You haven't allowed, you just been making all the decisions for me, even though you know
I
told
can't
you
wait.
that I don't understand, and you still make decisions based on my behalf without my consent, without me. I'm telling you I don't understand, and you still make a decision determining my life.
This is gonna be one of the best grand
Are
finales.
you telling me, sir, that you will refuse to follow the simple rules of decorum, courtesy, civility, the rules of evidence, and the rules of procedure?
Don't try to come with your slick words and don't put words in my mouth.
Sir, I am not being slick. I'm trying to
You've
preserve the
been
integrity.
slick. You've
Alright.
been slick.
All right, I'm gonna mute you, sir, since what you are saying is not productive. It is not courteous. It is disrespectful.
I don't care.
I need to go
I don't
over
care
these.
what you think.
All right, I'm muting him because I need to go over these important issues that have been raised by the state. So as far as the alternates,
He's
I
like,
do think
"Oh,
it is important
right in the
to
trash. He
keep
ain't reading
the
shit. He don't give a fuck.
alternates who in a secure location, even if that means an overnight, unless and until verdicts are reached in this matter, and I will so instruct the clerk of courts to make those arrangements. We have been doing that all along in any event. As far as selecting the alternates, obviously each of our jurors have a number. I intend to have pieces of equal size pieces of paper made, folded up with each of their
I think
numbers,
general
put them in
population is
the
gonna have equal size
same
pieces of his
turnstile bin that was
ass.
simply, and then the numbers liberate appropriate information regarding sequestration, the purpose of it. If I have not made that a part of the record, I will make sure to get a copy of that. Okay, thank you.
It's not just a book, it's the book.
Can't disagree with you there, sir.
Yeah. How many people actually live by them? Anyway.
Sir, I'm contemplating putting an hour time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm
Given,
not doing it tomorrow.
then you'll forfeit your right to give one, sir, because as we have,
You can't force me not.
Yes.
What type of court is this where you can say you're gonna
Yes.
force somebody not to be able to give a closing argument? How's that lawful
sir,
law?
if you choose not
How's
to
that
give
lawful law?
one,
How's that lawful law?
sir, if you choose not to give
Good.
one, you're not letting me finish, and you're mocking me right now, which is incredibly disrespectful once again.
Okay,
You didn't even let me get my sentence out.
You always want to make a incorrect record. Go ahead, take your incorrect record, go
All right,
ahead.
I'll mute him once again because clearly he just wants to be disruptive this afternoon. But as we have been talking about over the course of the last, 10, 15 minutes, talking about the timing of everything tomorrow, even though I have 107 pages of jury instructions, the first 73, I think, deal with what is read prior to closing arguments. That means the parties should be prepared to give their closing arguments tomorrow afternoon. I will do my very best with just one mid-morning break to get through all of these, the first part of the instructions. Then the state will give its closing argument. I'm giving the parties 1 hour each. I think that's reasonable under the circumstances. Whatever the state doesn't use in its initial time of closing arguments, it can reserve for rebuttal. But then following the state, we may need to take a break of some sorts, probably before the defendant goes, just for the jury's sake and the party's sake. We will need a comfort break. But you should be prepared to go tomorrow afternoon. Then the state, if they have any rebuttal, will get up within that time limit. I will, myself, and I'll have my clerk make sure we accurately time that. I will read the final instructions, and I'll really leave it in the jury's hands. If they want to start deliberating, that's fine. If it's 7 o'clock at night, I'll probably tell them, we're gonna break for the night. They'll be sequestered, but they will come back and begin deliberations in the morning. That'll be Wednesday morning. But now that I've really kind of laid that out and thought about the break I will have for closing arguments with even my 107 pages, we can get this done tomorrow. And so that's my expectation. So, Mr. Brooks, I'll unmute you, but that is the expectation of the court, that closing arguments will be done tomorrow.
You can't rush you to judgment, or you can't practice law from the bench and tell me when I can do something and when I can't.
Mr. Brooks, I actually can, under all of the rules of procedure. It is my job to make sure there's effective and efficient administration of this trial.
Then I should be allowed to, and if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth. That they have the power. They have the power to nullify laws they don't agree
You are
with.
absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that. That is clear under the law.
I can raise what I want to raise. And you can't, so you added these jury instructions at the last minute, then you should have never approved them from the get-go because I never approved them.
Hold up. Did he just say he wants to nullify a jury to make it legal for people to run people over? Anybody who knows what a jury nullification means, that you change a law. Are you really throwing everything, including making it legal to run people over in a parade because you're pissed off and upset at your girlfriend? Oh my God. You're gonna hang, dude. Dude, they're gonna throw everything they've got at you. You are the biggest dumbass. Congratulations. You win 2022 Darwin Award, as far as I'm concerned. Legal Darwin Awards. Oh, yes. All right, so you guys need to help me find some more legal Darwin Awards. And that will be one of my next videos, I think. Oh my God, are you serious?
And you still pass it.
Sir, if you understand jury nullification, you understand jury instructions. It's clear to me you've done your
I don't care what
homework.
you're talking about. I don't care what you're talking about. I'm going to let them know that they can nullify any law they don't agree with, which is my right.
It is not your right to do that.
Say that it's not.
It is not your right to raise jury nullification.
Show me lawful law then. Show me.
All right, I'm going to mute him once again. He's starting to raise his voice. He's starting to hit his hands on the table. It's very clear to this court that it's going to be a challenge tomorrow during his closing arguments. He does not have an unfettered right to say whatever he wants or how he wants. If he is going to be adamant about defying the
Fuck She-Hulk, man. This is the season finale I've been waiting for.
court's rules, which I will tell him in part what they are today, and I will work on that as we break and have a very clear advisement for him tomorrow morning. He may run the risk of being put in the other courtroom because he'll forfeit by his conduct his right to be present here, and I will be able then to exercise the mute function. I have to balance, frankly, the fact that he's in custody, that it takes time for this jury to be excused. They have to walk an entire hallway behind me. I frankly don't want him to look worse than what he's looked, frankly, in front of this court when they haven't been in this courtroom. I need to preserve how he looks to this jury. And I will need a very clear pledge by him that he will follow the rulings that I make as it relates to the closing arguments. He
Good
cannot
luck.
raise jury
You guys
nullification.
fucking
He
do.
cannot raise facts that are not part of the record. He cannot raise subject matter jurisdiction. He needs to argue the facts based upon his theory, based upon the evidence that's been presented, and those are the bounds. If he's going to, I can only imagine there may be some objections by the state. If there is an objection, I expect that
can
he
only
will
imagine.
stop and wait for this court to rule on the objection. I expect that if I sustain an objection, that he will honor it. And if he can't pledge to follow these very simple rules of courtesy and decorum that are consistent with the rules
be
of
going out.
procedure and the rules of evidence,
He'll
then
forfeit.
he will be in that other courtroom for his closing argument, so that I can exercise mute, frankly, to protect how he looks to that jury. Because that is the balancing that I am tasked with tomorrow, is to ensure that this jury makes a determination based upon the evidence and the law. You do not
Right.
have a right to talk about sympathy. That's very clear in the case law, whether
Okay, let's make a bet. Tomorrow, how many times is the jury going to have to get taken out just during his closing arguments? I'm going with 3. I'm going with 3. And if I win, then you buy me a beer. If I lose, then I'll buy you a beer. Not everybody. The first person that bets, whatever. Anyway.
it's evidence or arguments. The juries, if you read through the jury instructions, sir, you will see they are specifically told they will not be swayed by sympathy, by prejudice, or passion. They are not to be concerned themselves with any penalties. You can't argue penalties. You can't argue jury nullification. You can't argue legal issues that aren't relevant to the elements and the other law that's in these jury instructions. And those are the very clear rules that you will need to follow. And like any other time in this trial, if you don't do that, you will forfeit your right to argue your case to the jury or forfeit your right to be present in this courtroom and appear from the other courtroom. And you are squarely put on notice of that here today, sir. With that, I think I've addressed all of the issues the state has asked me to address. Oh, one other issue, verdict timing. I know we have some time on this. I realize that there are many, many victims who may still be watching the proceedings remotely. There may be news media, in fact, that may want to cover their verdicts, and that this jury will take some time due to the sheer volume of counts in this case. When this court is advised that verdicts have been reached, I'm contemplating between 30 and 60 minutes before bringing everyone back into the courtroom for the verdicts to be read in open court. And if parties believe I need to wait.
That's actually interesting. Being that he's got so many counts against him, it's going to take a long time to read. On count of 1, vehicular manslaughter. On count of 2, vehicular manslaughter. Or whether they trumped it up or have it capital murder. Injury with a vehicular assault, or just how many counts are going to have of this one incident. It's going to be a whole day. That's going to be a whole day of having the jury read, the jury foreman read each count. Oh man, that's going to take a long time. Of that count, we, the jury, find the defendant guilty. For every minute he wasted with every stupid objection he made, not understanding, as he's pointed out very clearly, as he was warned not to represent himself because of, you're like in a room of professionals. Do you want to be an amateur in a room of professionals defending yourself? Probably not. Probably not. Anyway, oh god.
Longer, then let me know, but I think some of it will depend on how, is it late at night, is it during the day, you know, are we dealing with any kind of traffic issues? I realize Mr. Brooks has family in Milwaukee area that may want to be here as well. Even if I consider kind of, you know, the outlying areas of Waukesha, you could be as much as 30 minutes away. So that's my initial thought on that. Any statement from the state on that?
Not on that issue directly, sir. I'm sorry, Your Honor.
It's okay.
I apologize.
Any other issues?
Yes, my other issue as to verdicts was seating, if you intended to maintain the designated benches for the reasons you just said.
I would intend to keep the seating as is.
Okay, with the
The
reserve.
entire side behind the stake for victims.
Okay, and the other side,
Public.
reserved for the first 5 minutes, or is that open seating over there? Or do you
My
wanna think
previous, or my rule throughout has been 15 minutes. What I would say is any open seating,
What I gather from that is that this is a high-profile case in which there's going to be a lot of media people who are going to want to show up and get the verdict. Or get the, you know. Anyway, sorry.
we'll open the courtroom, it'll still be open the whole time because we're waiting, right? So it has to be. So any seat that's left open within 15 minutes, victims could also sit on the other side,
Okay,
if that's what you're asking me.
yes.
All right, Mr. Brooks, any further topics by you?
Am I muted?
No, you're unmuted.
So, again, I don't understand nothing you just said, but,
Oh, no, you don't.
I don't-
Because
how can
You
you,
know.
how can you deprive me of my constitutional right?
Failing
How can you
of
deprive me my
education.
constitutional right? How?
Sir, you can forfeit a number of constitutional rights by misconduct on your part.
Not if I reserve my rights, you can't let me reserve my rights and then take them from me.
Sir, I direct your attention to Chambers versus Mississippi,
I'm not
Rock
going
versus
to do that.
Arkansas, State
Because-
versus Anthony, Illinois
Did they
versus
reserve their
Allen,
rights? Did they reserve their rights?
the Beneby decision. There's a host of case law, sir.
Did they reserve their rights?
All right, sir, you are simply mistaken on that. So I'm muting him once again. He's not giving me any other issues to address. We are in recess.
Oh, I'm sorry, I have a few
Go
other.
ahead.
I'm
You
sorry.
do. I'm
Yeah.
sorry, go ahead.
I just wanted the record to reflect that at about 2:04 PM, your clerk had provided the final version of jury instructions to both the state and to the defense. I watched on video as Deputy Wittig left this courtroom, went over to the other courtroom, handed the final jury instructions to Mr. Brooks, and he
Actually
immediately
threw them
turned and dropped them
directly
to his left off the side
into
of the
the
table.
trash.
I can't tell from the video if that's where the trash can is located or not, but I did see that immediate response after he was handed the final jury instructions.
Yeah. Nailed it.
Another
Did that
thing.
include the verdicts or just the jury instructions? Okay, it's just the jury
what?
instructions. But thank you, because I didn't see that given some of the things I was looking at up here, so I appreciate that.
Were all jurors, or will all jurors then be
Don't worry
told
about
to
it.
report with an overnight bag?
That's part of the instructions that
Okay,
they were
and you're gonna
given.
make that available to us?
Yes, I'll get Lauren down here right away, and I'll make sure that before Mr. Brooks is taken
You
back.
said pack it up.
to
I
the
don't know
cell.
what pack it
I
up
see your
means.
arms waving, I'll get you in a second, that he's provided with that as well.
All right.
And you as well.
And then one final thing as to timing, and again, I don't mean to be disrespectful to Mr. Brooks or anyone involved in this matter, but should there be any guilty verdicts in this case, would you be intending to proceed to sentencing yet this week or at a future time?
You know, that's an interesting question because I don't know how many victims will want to speak. If we have time, I would certainly consider that. I mean, I have this entire week set aside yet. And I have Monday morning, but I have some other things Monday afternoon, and then I am not available the rest of next week. So it really just depends on the timing. I would need to know from both the parties whether they anticipate anyone speaking other than the parties themselves. Any family members?
Yes,
I don't
we-
think I need a PSI. This is a trial. This is not like a guilty plea, so. Mr. Brooks, I'll get to you. I'm unmuting you. Go ahead. Go ahead. You're unmuted.
And since we're all making records to make you look bad, I think we should say for the record that one of the rights I have is to demand that the court place in the evidence any unrevealed contract, statute, laws, rules, or information being used against me under the Sixth Amendment. So how come that hasn't been placed in the evidence?
What law are you referring to, sir?
I'm referring to my rights under the Sixth Amendment.
And what
My
case law
constitutional
says you
right
have a
to-
right to do exactly what you just said you have a right to do?
The Constitution, Amendment 6.
Yeah, I'm just saying, if you can work on it, what,
Sir, that is very general,
if you got more.
your statement. It's vague. There's nothing
So we gonna go
specific
what?
you have
What
referenced.
You want paragraph 2 or something like that? Is that what you want?
No, that's not what I'm saying, sir. You're making
So,
general arguments
also-
that aren't based on fact and are overgeneralizations of what the law requires as well.
I accept value in return for value any documents in this matter. Since, it might be another record of what I'm doing, since it's always a record of what I'm doing. And I also have the right.
Those spindly fucking fingers, man.
Is this common law or admiralty law? Because judging by the gold eagle on top of the flag, it's some explaining that needs to be done. And that is a military symbol. So is this a common law court or admiralty law court?
Mr. Brooks, I'm frankly not going to address these nonsense legal theories of yours. I'm muting you. They have been debunked. They are typical sovereign tactics that have no place in our judicial system. We are in recess. I'll see everyone tomorrow morning at 8:30. I'll just direct you so we have the verdict forms to give. And if it takes us longer than 30 minutes, we'll make sure they're delivered to him in his jail today. Thank you, everyone.
Thank you.
That's what's up. Yes! Good job, Judge. Way to go. He's still running his mouth. Oh, it's been great.
Okay, so as far as you're concerned, this is fucking half decent and it's gonna work.
Which one?
The one I just picked up.
Lane, the lane?
Yeah. Okay. Alright, cool. Yeah, try not to fucking smoke too much in there if you can, because it fucking stinks.
It only stinks when I smoke. I make sure that when I come in the morning that I haven't smoked in here too much. Make sure I don't come in here
Alright,
smelling like smoke.
Hey, do me a favour, see if you can get this little fucker formatted, reinstalled, fresh. This will be for Adrian's daughter.
What little fucker? If it works, right?
Yeah, I know it works.
Where's the charger?
In one of those boxes down there.
We
Okay,
have
I'm gonna
very
test
few.
this outside.
We have very few Apple chargers. That's not. I know you're coming in here trying to trying to
No.
quick and easy. I get that. Look, I get that, but it's not quite that quick and easy, man.
I know it's not, mate, and that's why I rely on you to.
All right, so maybe you should not just rely on me, man. Maybe I should be able to rely on you. And right now, I'm fucked.
I don't really understand how you're fucked.
Because you know that Friday was payday again.
Yeah, you might fucking.
I know.
I'm fucked as well.
Okay,
I've got
so you can't put it all on me. Oops.